Hear ye, hear ye, hear ye. All persons have anything to do for the Honorable Justice of the Appeals Court, now sitting in the Boston within for the Commonwealth, draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts. Court is now open. Please be seated.
Morning, Chief. Good morning, everyone. Welcome to the Massachusetts Appeals Court on this Tuesday, July 7th, 2026. 45-year from the nomination of Sandra Day O'Connor to be the first female Supreme Court Justice. I'm Justice Joseph Ditkoff. To my right is Justice Catherine Hand. To my left is Justice Marguerite Grant, and we'll be the panel for all 6 cases today. This is quite a crowd. The Chief was joking that you surely come to see me, but we're very happy. We didn't used to do July sittings. Our first July sitting was in 2017, but I've sat in every July that I've been a judge. And one of the great benefits of July sittings is that we get to have all the summer interns who are in town come here and see some arguments. So I want to welcome our Committee for Public Counsel Service interns, our Juvenile Court interns, our Middlesex DA's interns, the Appeals Court, the Supreme Judicial Court, and the Judicial Youth Corps. I see we've got the clerk here. I'd like to welcome him too. So we're very glad to have you all here, and hopefully you'll find it interesting and informative. I'd like to invite all the interns to stay through the arguments and to stay after the arguments, and we'll come and we'll have a little question and answer and talk to you if you have the time to stay with us. I know we've got a lot of experienced attorneys, but also some relatively new attorneys, so we've got a clock here. Each side gets 15 minutes. The clock will count down. It'll be green at first. When we get to 90 seconds left, it'll turn yellow. When you run out of time, it'll turn red. And then it will start counting up. If it's red, that number is not how much time you have left, it's how much time you're over. So if it turns red, please finish your sentence, but don't say anything else unless you're answering questions from one of the judges, in which case please do finish your answer. There's no rebuttal in the Massachusetts Appeals Court. I assure you that my colleagues and I have all read the briefs. We have gone through the record. We've looked at some of the videos, and so you're best served jumping right into your argument. We don't need the background. All right. With all that having been said, I'll call the first case today, Commonwealth versus Johnson, number 25P 833. And here's one of our experienced attorneys. Whenever you're ready, Counselor.
Thank you. Please the court. Adriana Contratesi for the defendant appellant, Mr. Johnson, who contends that he is entitled to a new fair trial on 2 grounds. The first ground is that the trial court denied his new trial motion. And the second issue to be presented is that the prosecutor really exceeded the bounds of well-settled rules of closing and opening argument, and it did create a substantial risk of a miscarriage of justice in his conviction. Now, as to the new trial motion, I understand that the last-minute evidence about the picture on the cell phone was not exculpatory by far, but there still is something that makes it understandable why a defendant would feel that he did not have a fair trial, in that maybe he was not able to really assess in terms of due process, the strength of the Commonwealth's case in terms of making a decision about, well, should I make a plea, or what kinds of strategy should my counsel follow? So as set out in the Brazila case, that does talk about that test of evidence that was not disclosed until the last minute. And I'm not even really sure that you could fairly say it wasn't disclosed at the last minute. I assume it was always sitting in a clerk's office. But it was very inculpatory, and I do think that it did affect the due process implications of the trial.
Was the screensaver in the Commonwealth's possession, custody, or control?
Well, the screensaver would have been in, yes, the Commonwealth would have had all that evidence, but generally, defense counsel will make an appointment to go through all that evidence prior to trial.
Do we know if there was a passcode or something that the victim had to enter in order for the prosecutor to get access to the screensaver?
Well, one of the things that the prosecutor did say was that she had one of the detectives charge the phone, and she was very candid about that. But no, there was no mention of. She did have one of the detectives charge the phone, and the picture of the screensaver came up. But there really wasn't any indication of how that happened to come up. And you do have to wonder who did first get into that phone and how.
So it's agreed, as far as I can understand, that what we're talking about is prejudice resulting from the delay in the disclosure of the screensaver. Is that right?
Well, this was something that the defendant could always have sought out an opportunity to charge the battery and put the battery into the phone. So no, it's really not, and that I think is why the defense counsel chose to proceed on an ineffective assistance of counsel claim for a new trial motion. But really, that is the bottom line. To what degree had the phone been gotten into prior to the prosecutor making that proposition to the court on the day of trial?
What in our record tells us what the defense counsel would have done differently if the screensaver had been known before it was?
Well, and that's why I talk about due process. Really, you can't say that it is not. You can't say that it's not inculpatory. It certainly is inculpatory. But just as to who did the phone belong to, but it does implicate due process because it deprived the defendant an opportunity to really assess the strength and weaknesses of his case and to mount a defense. So that's where I think that the real problem with that is.
Okay, but part of the argument is, if I'm understanding correctly, that, for example, the judge should have sua sponte granted continuance to the defendant to give some thought to what else to do with the that anything about the defense strategy would have changed if that continuance had been granted?
Well, I might have reconsidered a guilty plea for my client.
Right, but is there anything in the...
Why isn't that a valid strategic choice?
It is a valid strategic. It is a valid strategic choice. That there is the problem about the blood on the phone. So things did stack up on the inculpatory side of the phone. But when you consider what happened with the phone, combined with the problems in the opening and the closing argument, where the prosecutor's comments completely robbed the jury of their fact-finding function in identifying the defendant as the perpetrator, when there really is a question if he is the person on the video. I'm sure that the court has seen the video, and you really can't tell who is on the video. Every single case that the Commonwealth cites as to the parameters of a fair opening and closing argument in their brief on pages 33, 34, 35, and 36, every single case gives parameters that the prosecutor in this case completely exceeded. Even in the Davis case, where the court found that the comments, well, combined with another issue of the GPS, created a substantial risk of a miscarriage of justice. In that case, what the prosecutor said was it was unreasonable and did create a substantial risk of a miscarriage of justice when the prosecutor said, you will be able to tell that it was Mr. Davis. You will be able to tell that it was Mr. Davis.
But where did the prosecutor tell the jury that they could tell just from the video that it was your client? I didn't see that.
Well, on page starting on page 34 of the defendant's brief, and by the way, this is Attorney Deal's excellent brief. I stepped in at the last minute to take over for her. But starting at page 34, she goes through all these comments. You will see from the surveillance video that the defendant has in his left hand. And then again, you can see the defendant. The surveillance video shows the defendant. This is the exact same person. This is so not what is permissible in an opening or closing argument. Every single case, for example, the Commonwealth, for example, can encourage the jury to infer facts from the evidence to arrive at a particular conclusion. Look, I suggest that you can find that it's the defendant because of this, this, and this. But what you can't do is, this is exactly the defendant. It looks exactly like him. And all this case law is so well settled, but it is exactly
In some of the surveillance video cases, the jury doesn't hear from an eyewitness who was at the scene the way this victim was. It might just be a surveillance video of a drive-by shooting, say.
Yeah.
And so in those situations, the prosecutor has to be careful in his testimony that this was the defendant putting, with a gun pointed directly at her back.
Because it's up to the jury to decide whether or not, in fact, it was the defendant who was pointing the gun at her back. That was the entire fact issue for the fact finder to decide. And the Commonwealth's opening and closing argument completely robbed the jury of that fact-finding function. So I do think that it did create a substantial risk of a miscarriage of justice. There was a lot of evidence in this case, and the Commonwealth essentially took away the primary issue that was before the jury. In Commonwealth versus Broome, there was an assault and battery with a dangerous weapon, stabbing, same thing. The Commonwealth's closing comments never even got close to anything like that. The same thing in Brazilla, a first-degree murder, same thing. Commonwealth versus Roy, that was a terrible, extreme and atrocious murder where the defendant killed his wife out in the woods. A victim had seen, sorry about that, an eyewitness had seen the victim out in the woods barefoot, and that was the testimony. In the closing argument, the Commonwealth said something like, and there's the victim out in the woods, barefoot and scared to death. Well, that is a great example of how to make suggestions to the jury about what they can conclude based on inferring from the facts. Not that, and there was the victim that the defendant killed. Completely different, or there was the defendant. In Commonwealth versus Fazio, we have a recalcitrant victim who was not entitled to a Fifth Amendment privilege, and the court found that it was completely fair to mention something like that in the closing argument. None of the cases that the Commonwealth cite say anything about the Commonwealth being able to tell the jury this is the exact same person. And again, in Davis is probably the case that is closest to ours, where the evidence, the video was very grainy. And the most that the Commonwealth did was just suggest that this could be the defendant. Combined with the GPS issue, it was a substantial risk of a miscarriage of justice. But that's not the same. And remember, too,
there was also in Davis, am I correct, that there was no direct identification of the defendant by an eyewitness? There was someone who said the defendant has similar hairstyle, but wasn't that person. We have different facts in this case.
Right, but look at how different the closing comment was. And I already, sorry to repeat myself, but you will be able to tell that it was Mr. Davis. That in nature is completely different way to frame a closing argument than the way that the Commonwealth did it in the instant case. And as Justice Grant did point out, this is always, identifying people on a video is always an opinion. It's always an opinion, and those kinds of opinions are only allowed when the expert has, when when the person giving the opinion knows that person in the video very, very well. For example, like the Please case, where the police officer who identified the defendant had known the family for 25 years. So the rules are very clear that the Commonwealth did overstep the bounds of fairness in their closing argument. And I think combined with the confusion with the phone, it did create a substantial risk of a miscarriage of justice, and the defendant should be entitled to a new fair trial. I don't have anything else. If the Commonwealth, if the bench has any other questions, I'm happy to answer them. Otherwise, I'll be happy to rest on my brief.
Great. Thank you,
That was
Counselor.
helpful.
All yours, Jennifer.
All right, we'll hear from the Commonwealth now. Whenever you're ready, Counselor.
Good morning. May it please the court, Jennifer Thompson, representing the Commonwealth, Bristol County. To address the first issue regarding prejudice to the defendant, Judge O'Shea denied the defendant's motion for new trial. I'd suggest that decision was not manifestly unjust. He did not abuse his discretion in doing that. And part of his decision, he noted that the defendant failed to establish prejudice because they did not offer an explanation as to how the defense strategy would have differed at a new trial. And I'd suggest the same issue is presented here in the brief of the appellant. The defendant has again failed to establish how he was prejudiced by the late disclosure of the screensaver in this case. So given that there is no proof or no indication that the defendant was prejudiced, I'd suggest that Judge O'Shea's denial of the motion was proper, not error, and not an abuse of discretion.
What do you think of your friend's suggestion that, regardless of whether that's true, the sort of atmospheric unfairness can be part of how we analyze a substantial risk on the closing argument?
That combined with the closing argument, I'd suggest there was no substantial risk of a miscarriage of justice here because the other evidence against the defendant was strong. Even without this screensaver, the jury heard that the victim of the robbery described the person. That person was on video. The police located that person within a short period of time of the robbery, within a short distance where the robbery took place. The defendant or the person that committed the robbery ran towards Providence. The police went in that direction, see a person fitting that description, running, jumping over 2 fences. They locate that person. That person is identified by the witness as the person that robbed her. Her phone is located. She's able to identify her phone by looking at it. She described it as a white older model J7 Samsung phone.
Right,
So
but at the time that she lost her phone, the phone had a case. It didn't have a case at the time. It didn't have a battery in it. There was no other distinctive identifying markings other than the color, age, and make of the phone, right?
correct. But given the circumstances, I think the inference made even by her, given that the person that took her phone appeared to be the same person that was located in a short distance after the robbery, that the inference could be made that, yes, this is my same type of phone, and given the circumstances, that's my phone. So in this particular case, I'd suggest the combination of factors, the delay in the screensaver, as well as the prosecutor's closing argument, didn't result in the substantial risk of miscarriage of justice. Excluding those two or statements by the prosecutor, I'd still suggest those weren't erroneous. But excluding that and excluding the screensaver, again, the jury, I don't think, would have had any difference in the verdict here, given the amount of evidence against the defendant.
Do you think it would have been better practice if instead of arguing you can see on the video the defendant pointing the gun at her back, if the prosecutor had said you can see on the video the assailant pointing the gun at her back?
Yes, in retrospect, yes, it would be better practice just to avoid the issue. However, in an opening statement, the jury is instructed that the openings is not evidence. the jury in this case wouldn't have understood the prosecutor to say that person on the video was the defendant. They heard that the upcoming evidence would point to the defendant being the robber. So in this particular case, again, yes, the better practice would have been to say the assailant was captured on the video, the assailant was the person, the defendant was identified as the assailant. But again, I'd suggest that there's no error or no error for the Commonwealth to argue that, because in this case, unlike in Davis, as the court indicated, that there was an identification, and Ms. Rotundo Nichols, the victim, shortly after the robbery, goes and identifies the defendant. When she had described him with a certain appearance, she says, yes, that's him. I recognize him from his nose, eyes, clothing, distinctive shoes. So here, the inference is that the same person that committed the robbery is the defendant. So again, I'd suggest that there's no error for the prosecutor to make that inference.
Do you have a sense on whether this wallpaper was something that, just appeared on a charged locked phone or only appeared once you unlocked the phone?
I'm sorry, could you repeat your?
This wallpaper with the family.
Yes.
Do you have a sense whether that's just what appears when the phone's locked and you hit it, or whether it's something you have to unlock the phone to see? I'm an iPad guy, so I don't know. Samsung's Gurk.
Outside of the record, I don't know my own experience. I could fathom a guess, but on the record, the prosecutor did inform defense counsel and the court that she had the detective place the battery in the phone, and when he did that, the screensaver popped up, essentially. So I could make the inference that there's no passcode needed in not being familiar with this particular cell phone, but cell phones in general, I'd suggest that a screensaver, you wouldn't necessarily need a passcode to observe that screensaver, if that answers the court's question.
Very much. Thank you.
As far as the other statements in the prosecutor's closing, again, I'd say that they're not outside of the bounds of reasonable argument here. The prosecutor's entitled to comment on the defendant's credibility in his testimony. I'd suggest that her statements were reasonable, given that the defendant claimed that this was a coincidence, and the police essentially were upset with him and essentially framed him. So I'd suggest that the argument saying that his testimony was ridiculous or completely unbelievable, again, is not prohibited in this particular circumstance.
That phrasing present any concerns?
I would say not, Your Honor, just based on the case law that's cited in the Commonwealth's brief. It's permissible at times to call the defendant a liar based on the testimony if there's two varying stories. You could just certainly make the comment to the jury that the defendant was not telling the truth, or even phrase it as he lied or is a liar. That's been upheld. The only statement that did cause some pause was when the prosecutor indicated that you should not believe a word of it. But I'd suggest, again, that was not saying I don't believe a word of it. It's not her own personal opinion. It's just commenting on the unbelievable, incredible story that the defendant had offered to the jury. And again, I'd suggest that given the amount of evidence against the defendant here, the statements of the prosecutor wouldn't have led to a substantial risk of a miscarriage of justice in this case, just because the jury could disregard those comments and still find the defendant guilty. And are there any further questions by the court?
I see none.
All
Thank you,
right.
Counselor.
With that, I'll rest on my brief. Thank you.
Thank you both. It's a really interesting case, and you were very helpful, both of you. Obviously, students, when you're doing a moot court, you got to take the full time. But that's not the way it works in argument. The best argument I ever saw, which was given by Judge Bucci back when he was a ADA, was about 30 seconds long. So, thank you both. All right, well, oh, sorry. For our benefit of our interns, we've got both a Committee for Public Counsel Services attorney and a juvenile case, so that should be great for the interns we have here. So I will call the next case, Commonwealth versus a juvenile, number 25P 500. I know you know, but I'll just remind you, we're not going to say the juvenile's name, just call him the juvenile. Whenever you're ready, Counselor.
Thank you. Good morning. May it please the court. My name is Taylor Henley, and I represent the appellant juvenile. A black teenager was sitting calmly in a parked car when he and his companions were ordered from the car and frisked, despite neither he nor the car matching any descriptions provided by the 911 caller. Because there was no reasonable suspicion that he had either committed a crime or was armed and dangerous, both the exit order and the subsequent pat frisk were unlawful. I'd like to begin with the proportionality of the exit order and then turn to the pat frisk. So turning first to the exit order. Article 14 requires that an exit order pursuant to an investigatory stop be supported not only by reasonable suspicion that a crime had been committed, but also proportional to the degree of suspicion that prompted the intrusion. Regarding proportionality, the motion judge here deemed it reasonable for police to issue the exit order to determine if the occupants matched the description given by the 911 caller. But that order was not needed to determine this. This occurred in daylight. There were 2 doors open already to the car. Commonwealth suggests that it would have been dangerous for officers to peer inside the open doors, but in fact, in looking at the body-worn camera footage, one officer does just that. In addition, there were a number of steps that officers could have taken, short of issuing an exit order, to determine whether the juvenile in this case matched the description from the 911 caller.
So if there's someone in the car, not your client, who matches the description of someone who has a gun, why isn't it reasonable, while you frisk that guy, to just get everyone out of the car, not to frisk them, but just get them out of the car while you frisk the one person that you have reason to frisk?
Because if, as the judge found, the exit order was reasonable to determine if other people matched the description, that was not needed here. Officers could have asked the other occupants in the car to roll down the windows, for example.
No, but once they decide that one of these occupants meets the description, not your client, the other one, who meets the description of the person with the guns, and now they need to frisk the person, why isn't it reasonable at that point to have everyone else just get out of the car while you deal with a frisk of a person possibly armed with a gun?
Because an exit order is a constitutional intrusion, Your Honor, and so while it might not be quite as intrusive as, for example, a pat frisk, it is still a constitutional intrusion that requires both reasonable suspicion that a crime has been committed and proportionality. And so while it might seem reasonable to a bystander to do that, the police are still required to follow the Constitution in Article 14 in this particular type of constitutional intrusion. And our contention is that they did not do that here because there was no reason to do so to determine if my client matched the description provided by the 911 caller. This requires a balancing test, as Commonwealth v. Torres tells us, balancing the need for the intrusion with the severity of the intrusion. Obviously, this is not asking someone to exit the car, as I mentioned, is not a significant intrusion. But here, where there are no factors on the other side, there are no reason to issue the exit order. That balancing test tips in favor of the juvenile.
There's no factors on the other side? We have this situation where somebody has reported that there's people running around their yard with a gun, a kid is home alone, and do you think the police should have just said, sorry, have a nice life?
No, certainly not, Your Honor. I would not suggest that. I think the police can and should investigate these type of situations, certainly when anyone is calling, reporting someone with a gun. They can and should arrive and investigate the scene, as they did here. What I don't think they can do is immediately frisk everyone in the vicinity who was black and who was male and issue an exit order and frisk everyone in a parked car that's not even in front of the house that was calling from.
I'm going to ask you a hypothetical question. Assume for the sake of argument that one of the police officers radioed the dispatcher and said, "Could you tell me again the description of the people?" And the dispatcher said, 2 skinny black guys wearing all black, one wearing black Air Force One sneakers, the other one wearing a black Air Force One sweatshirt. And one of the police officers said, "That's the guy. I just saw him go around the back of the house and get into a car up the street." If the Commonwealth had elicited those facts, would that have been enough to create reasonable suspicion for the police to order the guy in the back left seat, driver's side, out to pat frisk him?
I think probably. I think it would probably depend on the car, right? If the officer had said, "I saw this person get into an orange convertible," and then, police see an orange convertible, right? That seems pretty...
Or a green Honda.
Or a green Honda Accord. But here, there are 2 things that are different in the hypothetical. The first is that no one mentioned the Honda Accord, not the police, not the 911 caller. And second, even if police had ordered the young person who matched the description out of the vehicle, my client was not that person. My client was sitting in the front passenger seat wearing a blue sweatshirt and white sneakers and blue pants. He was not wearing all black. He was not sitting in the back. He did not match any descriptions from the 911 caller. He did not exhibit any other types of behaviors that...
But it was a dark blue Nike sweatshirt.
It was dark blue, but when asked directly whether my client matched the description of the 911 caller at the motion to suppress, the officer who testified said no. And so I don't think it's been a contention, particularly at the trial court, that my client ever matched the description from the 911 caller. I do want to turn to the pat frisk. Even if this court deems the exit order justified by reasonable suspicion.
I have a question for you about the exit order.
Sure.
You argue a lot about the constitutionality of the exit order. We need to find where in the record the exit order occurred. And in order to do that, it would have really, really, really helped if you had given us a timestamp of the minutes and seconds of where in the many videos that we have the exit order occurred.
I apologize, Your Honor. I will be sure to do that in the future. If it's helpful, there are 7 videos. A number of them show the exit order. The way the videos go is the officers approach the vehicle and say...
We've watched the videos.
Yes.
The point is, when you watched the videos, it would have taken you a matter of seconds to write down the timestamp. We had to watch all the videos, and our law clerks had to watch the videos. That's hours and hours and hours of person time, when it would have taken you seconds to write down. And I know the rule doesn't explicitly require it, so it's not your fault. And we found where the exit order happened, so you don't need to tell us now where the exit order happened, but we did a lot of work to figure that out, just so you know.
Thank you, and I apologize, Your Honor. I will certainly bear that in mind for the future. I do think the context of all the videos, however, is important, not merely the moment of the exit order, because it helps set a scene. And with that, I do want to turn to the pat frisk if there are no other questions on the exit order. So even if this court deems the exit order justified by reasonable suspicion and proportional to the degree of suspicion, the subsequent pat frisk was illegal because there was no reasonable articulable suspicion that the juvenile in particular was armed and dangerous. The motion judge found that the pat frisk was lawful because it occurred in the course of a constitutionally justified exit order. This is incorrect as a matter of law. Although the facts that justify an exit order may be part of the consideration in the pat frisk analysis, the 2 standards are not the same. And in this case in particular, the factors that the judge used to justify the exit order do not apply to the pat frisk. Assuming reasonable suspicion existed, it existed only for the person who matched the 911 caller's description. Once it was clear that my client did not, the juvenile in this case, did not match the 911 caller's description, the need for additional intrusion dissipated. And removing him from the vehicle made it clear he did not. His presence in the Honda Accord with someone who matched the 911 caller's description does not change this analysis, as mere proximity alone cannot support a frisk, as cases such as Commonwealth v. Wing Inc. and Commonwealth v. Prevost tell us. So, police needed more information here to justify the pat frisk, which they did not have. The juvenile was not known to officers. He made no furtive gestures. He made no attempts to flee. Upon exiting the vehicle, the juvenile was described by the officer who testified at the motion to suppress as calm. His face was, and I'm quoting here, normal, fine, and he was fully compliant with all police requests. This is in contrast with cases in which courts have upheld pat frisks on similar grounds. For example, in Commonwealth v. Sweeting-Bailey, the 3 occupants in a vehicle were familiar to officers for firearms and gang-related issues, and one of the individuals got out of the car in an attempt to distract the officers. Nothing like that happened here. And this case is comparable to Commonwealth v. Greenwood, in which the defendant was cooperative, made no furtive gestures, was not hostile, and did not fly, had no flight. And the court deemed the pat frisk unreasonable at that point, as well as Torres Pagan, in which the defendant was pulled over, got out of the car without being asked, and turned to look inside the vehicle, and the SJC still found that a pat frisk was not justified. I want to address briefly the Commonwealth's assertion that the scene was volatile and dangerous. The Commonwealth claims that the scene involved multiple youths, several cars and mopeds, and a volatile street scene. But in fact, as we can see on the body-worn camera footage, only one moped was seen, and that moped rode up to police after police had already arrived and was very cooperative with the frisk of his person and of the moped. The body-worn camera footage shows parked cars lining the streets, but those are largely empty. And there was no claim from the officers at the motion to suppress hearing that the empty and parked vehicles posed a threat to their safety. The officers...
We do have a guy who's like constantly arguing with the police officers. Not in a dangerous way, but constantly. You'd agree with that, right?
Oh, certainly. He was described by the officers as pretty upset and hostile, but I think understandable hostility in response to a violation of your bodily autonomy does not equal danger. But even if you think that that person who was arguing with the police could have presented a danger, my client was not part of that group. When police arrived, as you know from the body-worn camera footage, there were 2 groups. There was an initial group the police spoke with. Those were described as being hostile towards police and upset. You can hear them arguing with police, particularly about the frisks.
And the guy in the orange sweatshirt is arguing about the frisks and telling police specifically that they shouldn't be frisking somebody because he was young.
Yes.
And one of the things that the caller said was, look at the guy in the orange sweatshirt, look in his backpack.
Yes.
If the Commonwealth had done more to elicit information about that, could it have possibly given rise to an inference that the guy in the orange sweatshirt was trying to distract police from pat frisking anyone who was young because he was going to hand off the gun to the youngest person there or one of the young people there?
I don't believe so, Your Honor, for a few reasons. First, the person that was young that he was describing, my sense from that is he had said something along the lines of, and excuse my language, he's effing 11, bro. That person had rode up on the moped after police had already arrived.
Well, your client was young.
He was, yes, but he was not 11. He was 16. But there is a bit of a time gap in between when this happens and when another officer walks up the street and sees the Honda Accord and sees inside to see that someone in the rear of that vehicle matches the description, because he then comes back to the other officers and says, and I'm paraphrasing here, something along the lines of, there are black Nike Air Forces in that back seat, black pants and black Air Forces in that back seat. It's not quite as immediate as I'm going to distract by being annoying in the first group so that officers don't see the second group. I hope that answers your question. And last, the Commonwealth does claim that officers did not frisk a dozen youth, but rather methodically assessed groups. But frisking is not methodically assessing. It is a severe intrusion upon cherished personal security that must surely, and I'm quoting here from Torres Pagan, must surely be annoying, frightening, and a perhaps humiliating experience. This is particularly significant for communities of color, for whom pat frisks disproportionately affect, as we know from Commonwealth v. Warren.
I'm afraid, Counselor, we'll have to leave it at that.
Oh, I apologize.
No problem.
Thank you.
Thank you very much. We'll hear from the Commonwealth now. Whenever you're ready, Counselor.
Good morning, Lindsay Conkey for the Commonwealth. This case turns on a very narrow question, which is whether at the time Officer Ryan effectuated the pat frisk, was there a reasonable suspicion of the juvenile? And the answer is yes. And we get to that answer by looking at all of the facts, because this is a totality evaluation here. So we start with a 911 call. We have a scared child. He's calling his mom. He's afraid to leave his house because he sees multiple young men, firearms, they're drinking, they're smoking, there's vehicles, there's mopeds. He won't even go outside. We have him call. The mom is on the line with the son at the same time, calling 911, relaying information, and then the cops show up to the scene. And it's a specific location. It's her home. It's her driveway. This is not, a 3-block radius. This is her exact home. They're in her yard.
Is her yard immediately adjacent to a public park?
Yes.
And is there a parking area for that park or for the building between those two?
Not between the location of the home and the park. There's a long driveway that runs the whole length of the home. I'm not sure about parking lots on the other sides. I know there's a map submitted, so you might be able to see it that way. But so the police get there, and I'll speak about Officer Ryan specifically because there were a lot of officers who arrived on scene. He testifies at the motion to suppress hearing that he gets there and he sees the Honda Accord. And yes, that has not been reported by the son, but it doesn't mean that the officers can't come and use their own eyes to evaluate the situation. And he testifies that he sees that car. There's 5 individuals all combined standing outside, inside, and he decides they're going to go check it out. And it's not then that he decides to do the exit order. He decides to do the exit order when he gets to the car and he sees that one of the people inside of it, their clothing matches the description that has been given on the 911 call. So we don't need to decide whether the exit order was valid just from seeing the car. What we have here is reasonable suspicion that one of the people who was on that 911 call, reported by that scared child, is now inside this car. And what's more, we have Officer Ryan testifying that based on his knowledge and his training, handguns are small, and they can easily be passed from individual to individual.
So does that mean if Mayor Michelle Wu was standing there, the police could have pat frisked her because somebody could have passed off the handgun to her?
If she is standing there, this is a reasonable suspicion standard. This is not a probable cause. So would it be reasonable for an officer with his training, knowing that individuals inside of cars often will pass firearms back and forth? Yes, that is a reasonable suspicion. I don't know that it would be enough to, like I said, it's not a probable cause level, but yes, for when there's multiple firearms, they have not located any of them yet, and they have individuals inside of a car. And the judge credited the officer's testimony and his training. So that is the basis of the finding.
Do we know anything about which officer's attention was first drawn to that car and why?
I don't. At the motion to suppress hearing, there was 2 officers who testified. Officer Ryan, who is the one who effectuated the pat frisk, testified, and then Officer O'Loughlin, sorry, I'm not sure which one it is. Those are the only 2 who testified at the motion to suppress hearing. I believe in Officer Ryan's testimony, he says on page 15 of the motion to suppress hearing that his attention was drawn to it simply because of its proximity to the gray Mercedes, which had been reported by the child in the call, and also because there was the 5 individuals surrounding the car.
I'm going to ask you the same hypothetical that I asked
See who's
defense counsel. Assume for the sake of argument that the police are standing there and they radio for the dispatch to repeat the description, and then one of the officers says, "That's him, that's the guy." And that's what caught, and he went around the back of the house and he got into a car up the street. Wouldn't it have been a good idea for the trial prosecutor to have elicited more information about that?
Certainly, it may have helped the case. However, we have enough that was elicited, which is he saw the car, he walked up to it, he had not done anything yet, he had not issued the exit order, he had not done any pat frisks, he just simply walked up. That's when he observed that one person inside of the car matched the description. So while more information would have been certainly helpful, it doesn't negate the fact that we had enough information to justify that exit order at that time.
You seem to be arguing that if the police have reasonable suspicion that one person in a car has a small weapon, that they can frisk everyone in the car because the weapon can be transferred. Is that what you're arguing?
In this instance, yes, given the testimony from Officer Ryan, which the motion judge credited, that based on his training, it was often that people would pass it around. So yes, that is what I'm arguing in this instance. I would not make it a categorical rule, but given the facts here, yes, I think that it was valid.
All right.
There are no further questions. Commonwealth will rest on its brief.
All right, thank you both. It's a very interesting case, and you've both given us a lot of information, a lot of help in deciding it. Thank you both. Right, the next case is Commonwealth versus a juvenile, number 25P558. Before we start, normally the seats in front of the bar are reserved for members of the bar, but under the circumstances, if one of you wants to sit in the the empty one, that's fine. All right, I will remind you that even though this is a hybrid youthful offender delinquency case under my own Demos D case, we treat it as the name completely impounded, and so we'll just refer to the defendant as the juvenile, and we also won't name the victim. We either call her the victim or BD, either are fine.
Thank you, Your Honor. May it please the Court, Margaret Carleen on behalf of the juvenile. The trial court made a number of errors at trial which warrant reversal. As there are a number of issues that are raised in the brief, I'd like to focus on two issues in particular, one being the challenge of Juror 82, and the second one being the restraining order evidence that should have never been shown to the jury.
I'm sorry, what did you say was the first one?
The first one is the challenge of Juror 82.
Okay.
In preparing for this argument, it's become clear to me that this really was a for-cause challenge. While it was briefed a little differently, the issue was that juror number 82 was scowling at the juvenile. The information was immediately reported by counsel to the trial judge. At a minimum, the judge should have conducted inquiry to investigate the issue. There was nothing to undermine those statements made by defense counsel that the scowling had occurred. For example, there was no comment by the prosecutor or the trial judge that this person was in their line of sight or that they had seen this juror and hadn't seen any problem. There was nothing to allay the concern. It was just an unaddressed report of a scowling juror. And the negative bias that implicates is a concern. Obviously, it's fundamental to our criminal justice system that a defendant or juvenile, in this case, get a fair and impartial jury. So it was incumbent on the judge to make an affirmative inquiry as to the juror. And that minimum step is typically, of course, a voir dire. That was not done. Whatever words trial counsel used, it should have been recognized right away as a for-cause challenge by an experienced trial judge. And similarly, in the same case.
Didn't the defense lawyer need to bring that up at the time? This is a for cause. I want you to question the juror, instead of just trying to, use a peremptory?
We understand that she used the wrong words. The facts and the important information was relayed to the judge. This was enough to put whatever word we would argue it's irrelevant what word she said. She meant to say for cause. The trial judge was on notice of what type of problem this was. When there was a juror with earbuds sleeping, she immediately recognized. There was no discussion of whether it was for cause or peremptory or trying to characterize it. Problem is obvious. There needs to be an impartial jury that's going to pay attention to the facts, and the judge didn't conduct an inquiry. The argument might be diluted if there was a voir dire and there was some information coming to the record to allay the concern, but the one person that could have done that wasn't asked any questions. Second problem, now that we argue that we have a biased juror on the jury, is that there was improper restraining order evidence that came in. Defense counsel had already filed a motion in limine. The judge agreed that that was impermissible and shouldn't be heard by the jury, and had to do nothing further because under Grady, the issue was preserved and didn't need to do anything further. This was the same parties, the same issues were litigated in that restraining order hearing. So not only did that evidence bolster BD's testimony, but it carried the impression of a
How would the jury know the restraining order was granted? They knew there was a restraining order hearing, but how would they know that the victim had prevailed?
I think the power of of BD's testimony, it indicates that she showed the judge her bruises, and he fought me on it. I think it's a very strong implication. There was also the issue that this compounded when the process. Now, I understand she felt that the juvenile's mother had testified to some incorrect information and wanted to correct the record, but that should have been struck at a minimum. She then carried the transcript up to the juvenile's mother. And somewhat, I think, for a jury, that's a bit theatrical because the paper is in her hand, carries it up in front of the jury to the juvenile's mother, and then actually has the juvenile's mother read the transcript into the record. And the prejudice of this was enormous, especially in a case where credibility went to the heart of the defense. Juvenile was arguing that he did testify too. They both testified in the trial. And then compounding the, I'm sorry.
Oh, go ahead. I just say if you'd like some direction. I was having some trouble following your specific unanimity argument and your text messages argument.
Well, the argument essentially is that the jury was asked to rely on some text messages that came into evidence where there was no sender identified, no date identified. They were looking at, this is over a 4 to 5 month period, a series of interactions with the two teenagers, conversations, events, and there was no specific unanimity instruction given. So there was a serious likelihood that the jury would have been confused because there's no way to know on this record what set of facts they were looking at to make the determination to reach their conclusions.
Like for which charge do you think there was needed to be a specific unanimity instruction?
Yes. This was a number of charges. The case law also kind of mirrors this, where it was a number of charges on different counts and different counts for different crimes on the same dates. So it was really a confused amount. There's just absolutely no way to know what the jury was thinking, whether they relied on the specific bundle of facts that the case has referenced. They could have been thinking of different things. There's just no way to know. And there's no instruction. And with the concern with confusion as we have in this case, that should have been given.
But as to which counts should there have been a specific unanimity instruction?
I'm sorry.
To which counts should the specific unanimity instruction been given?
I think on all of them. I think the jury was asked to compile a number of facts that went into the record. The text messages, again, had no identification. And it wasn't just text messages. It was a jumble of events and interactions. The facts section that both counsel and I briefed was fairly lengthy. It's a lot of facts. So there's just no assurance that they were unanimous on any set of facts in reaching their outcomes, their decisions.
And could you walk me through what you're arguing in your argument for, in argument for about the text messages, or just go to the specific unanimity, or is there something else? You mentioned counterman, and I wasn't sure.
Rea issue, yes, Your Honor. There was no mens rea instruction. The concern with these texts is many of them contain language that is just generic teenage slang. You know, maybe in the day someone would say, "I want to kill you." Nobody would take that serious. It's obviously facetious language. Here they'll use language like "die." It's terrible, it sounds offensive, but it's not clear that they really want the person to do that or that there's any mens rea or intent behind any of those statements, particularly when we see BD's responses, which are very casual, and her own texts back, which repeat the same language.
So what should the instruction have been?
There should, with respect to specific language, I'd like to look at a model jury instruction, but it should have been something to the extent that you must find that the juvenile had intent when he sent these messages, or if you are to find on that issue.
But in order to do what? Like, you can't consider the text messages unless you find the counterman intent? Is that the instruction, or is there? I'm just trying to figure out. I understand, what counterman requires, but in order to do what?
I think in order to make a finding, I think that was on the stalking charge. So I think in order to make a finding
of stalking.
I believe so. Yes.
Okay.
Those were, and they probably tainted the entirety of every count in there. I think the charges of assault and battery and strangulation, they probably go to that too. Again, there's a concern. It's not very clear what the jury did think about or didn't think about, or whether they just, got it done. It's just very unclear, and the concern with prejudice is high. There's also another issue snowballing into this. So now we have, again, the biased juror, the restraining order evidence that we contend should never have come in, and I don't think the Commonwealth argues that it should have. BD then testifies that the juvenile is so bad that she can't go out in public anymore. She can't be in a room with men because she's afraid somebody's going to come out of the bushes and attack her. Again, that's improper. That should have been struck.
Wasn't proof of her fear relevant to crimes including stalking?
But her fear should have been connected to the time of the crime, not how she felt on the stand that day of the trial or any time into the future. And that's what the testimony
But if she's still alarmed months later, isn't that pretty good evidence she was alarmed at the time?
But I believe that it's a temporal issue where it has to be, it's only relevant how she felt when the crime was committed, not later.
Right, but why isn't how she felt later evidence of how she felt at the time?
I think that, well, I would argue those are two different things.
So is the defendant entitled to an instruction that she should just get over it?
No, not at all. It's not that. It's that I think that when someone is being charged with a crime, the evidence that comes in should be tethered to the point in time where they commit the crime, not into the future. And it also becomes extremely speculative, and it invited speculation and probably inflamed the jury, because it is inflammatory. It's talking about how she can't even go outside because of this juvenile. And again, taking all of these things together, it's an onslaught of evidence that should not have come in with an already biased juror sitting on the jury. There's also an issue with the video evidence that came in. We contend that that violates the wiretap statute, both federal and Massachusetts. In Massachusetts, it's illegal to record someone unless they have actual knowledge.
Right, but there's no exclusionary remedy unless there's police action involved. So I don't understand where the state statute gets you in this case.
Well, with respect to the state statute,
I know you think that was wrongly decided, but
yes.
we kind of got to follow what the SJC says,
Okay.
right or wrong.
In addition, before we even get to those issues, though, none of it was redacted. It does contain rank hearsay from BD, making a string of accusations that are recorded that the jury is hearing. Under the case law, that at least should have been redacted. And
So when the victim says, "You don't hit someone you love," and the defendant says something like, "Yeah, I do," that her statement should have been redacted?
In that instance, there's a weaker argument that it should have been redacted. But there is a large number of statements where he either doesn't reply or does outright deny it. And I don't think the case law requires that somebody say, I deny that. It's a teenager. And he says, when she says, for example, you wouldn't let me leave, he replies, I did let you leave. You did leave. That's a denial. That shouldn't have come in. Video 2 is simply a running list of accusations. It's not responded to, and that all came in. Again, that is something that is going to influence a jury against the juvenile, and it's a concern. Prosecutor centralized these issues in her closing. She devoted about 20 pages of the transcript to the video evidence. She made a comment. You heard from the juvenile himself that he was physically abusive. She cross-examined the juvenile on the video evidence. And so those issues prejudiced the juvenile. There were some other comments that came in, the police officer testifying that this is a strong, mature woman. That certainly shouldn't have come in, somebody's opinion about whether somebody is to be believed. Because again, credibility was at the heart of the defense. It was an issue where both testified, and he was arguing that he was to be believed and she shouldn't be believed. I would also argue that, going back to the wiretap evidence, the judge's findings were insufficient on those issues. The judge entered into analysis, which is a little different than what the Commonwealth is arguing, and tainted the inquiry so that it's not reliable when she analyzed the issue of whether the video evidence should have been entered.
Could you explain that?
Well, the judge found the first video, she used a preponderance standard, for one thing, which was problematic.
Well, why isn't that the standard? I would think all facts that aren't elements would be proved by preponderance.
I didn't see that standard articulated in the cases. It seemed to me that the judges analyzing that issue simply found whether the person had actual knowledge or didn't, not that they found it more likely than not. And the judge uses that preponderance standard on both videos.
So what do you think the standard is for that?
I think it's simply a finding. Based on the record, the judge makes a finding as to whether the person had actual knowledge or not.
But the judge has to do that at some standard, preponderance, clear evidence, clear and convincing, or beyond a reasonable doubt, or even a lesser standard. How does the judge analyze that when the evidence isn't?
I didn't see a standard articulated in the cases, but I would suggest that it should be more than a preponderance standard. If it's a preponderance standard, that wasn't articulated in the cases, and it should be higher than that. And if there are no further questions, I see I'm running out of time.
Well, thank you very much, Counselor. It's nice to see you doing criminal cases.
Good morning. May it please the court, Kristen Jang for the Commonwealth. And my sister has raised a series of pretty juicy issues, so I'm happy to answer any questions from the court, or I can go through them in kind of chronological order.
Well, I'd really like to talk about the counterman issue,
Sure.
which has now been clarified as a missing instruction for the stalking charge.
Yes, so this applies specifically to the stalking charge. And this also ties in a little bit with the specific unanimity instruction issue. So I think this case is really unique in that the facts were fairly complicated, but at the same time, if you look at the prosecutor's closing argument, I thought she did a tremendous job walking through which incident went with which charge, and the verdict slips also were pretty specific as to what the date of the offense was on each verdict slip. So I thought, given that, in light of the fact that there was no request for a specific unanimity instruction, I don't think that there was a substantial risk for a failure to give one sua sponte. As to the stalking charge in particular.
Do you think you get, regardless of what happens when it's not objected to, do you think a defendant can ask in a stalking case that there be specific unanimity on what the threat is?
I think that's fair. I think that would be a fair request. And, every case is different. And in this case, the prosecutor admitted, the stalking charge is probably the least clear cut, and that there was evidence of quite a number of threats in this case. So there were the text message threats that were in evidence, that were in writing. Those were very clear, but at the same time, the victim also testified that the juvenile repeatedly threatened to kill her during the final year of their relationship, threatened to kill her family, and that she testified that the texts were a very good representations of the types of things that he would say to her.
So considering how many threats there are, and none are particularly stronger than others, why isn't it a problem if the jury has to be unanimous on what threat is for the stalking case, that they weren't told to do that?
Well, there was no request for one. So you look to whether there's a substantial risk of a miscarriage of justice. And in this case, given that the jury clearly credited that the intent behind these texts, it would be hard for me to think of why they would credit one versus the other, for them to find that there was not 3 or more threats. This is not like there was a series of events that had equal amount of evidence, equal strength of evidence, and we're not quite sure which ones the jury picked from. I think the evidence was pretty clear as to each one of them, so I don't think there's a substantial risk issue here.
So you're saying it was an all or nothing proposition, either they believed them all or they believed none of them?
Great. So I guess I should walk back a little bit. So because there were the text messages and there was the testimony about these are the types of things. So I guess I could think of a scenario where the jury believed the text and maybe not necessarily the testimony about the threats that were happening verbally. So I suppose that could have happened. But at the same time, the nature of them were very similar. So I think if you're looking at a substantial risk standard, I'm not sure that that's there in this case.
So what about the absence of a counterman instruction on the threats?
Sure.
I mean,
Sure. So
do you agree, for instance, that there ought to be, I know there's no objection here, there ought to be a counterman instruction when you do stalking?
yes. So I think counterman is very much on point, and Cruz, I would bring up as a good contrast case because the instruction in Cruz was different than the one that was given here. I think that the instruction given here was much stronger. The judge defined a true threat as one that either threatens imminent physical harm or caused and was intended to cause the alleged victim to fear. So I think that intent language makes it even stronger, in my opinion, than what counterman requires, which is a reckless disregard for the risk that someone would be put into fear. That combined with the strong evidence here, I think there is no substantial risk.
What about the threatens imminent physical harm? I mean, that doesn't seem to require the intent. I see what you're saying about the intended to cause.
Yes.
But there certainly are threats of imminent physical harm here. So
There are.
how do we know the jury didn't decide it under that, where they shouldn't under counterman?
Sure. Yeah, that one's a little bit weaker, I will admit. But at the same time, I would contrast this with the instruction given in Cruz, which is a lot broader. Also, when you look at the actual threats made here and the nature of the relationship between the two, these weren't two strangers, where the perpetrator, the person making the threats, didn't quite know how the person would react. These were two people involved in a relationship.
But he testifies that he wouldn't expect her to react because this was the kind of sarcastic back and forth they always had. Now, I know a jury doesn't have to believe that, but...
Right. No, he did, and he's
But
entitled.
isn't there some evidence that he specifically did not
Yes.
intend them to be taken as real threats?
Yes, and it's clear that the jury did not credit that. Also, if you look at the context of the text messages, I don't quite agree with my sister that the victim's responses were casual. And at least one that comes to mind, she was saying something like, "You're really upsetting me, please don't do this, I'm trying to calm myself down." So it's clear that she wasn't taking these things as a joke. these statements as a joke.
Well, under counterman,
Yes,
if this was a perfect world and there was a perfect counterman instruction,
yes.
does the Commonwealth have to prove that he intended that she take his threats seriously? Or that he...
There's at minimum, a reckless disregard for the possibility that she would be threatened.
that he was aware that she could see his statements as threats and made them anyway?
Yes, there's at minimum a reckless disregard for that. In a perfect world, that would have been included in these instructions. I'm not contesting that. But I think under the facts of this case, and given that some intent language was included in the instruction, although there was that or statement there was some included here, so I think under substantial risk, it was enough here.
And this case was tried almost a month after counterman came down.
Yes. I agree, yes. I'm happy to go back to discuss the wiretap issues. I think it's very clear here that the defendant has to show that there was, that the factual findings made by the judge were clearly erroneous. I don't think there's a basis for that here. The judge credited the victim's testimony that when she pressed the record button, the juvenile was looking at her phone, and then his demeanor immediately changed.
Thank you for your 16L letter on Grimaldi.
Yes.
Now, in the cases, the wiretap cases involving police,
Yes.
like Grimaldi and Dew,
Yes.
you could read those to say that there's a bright line exclusionary rule that applies when the wiretap statute is violated.
Yes,
Why
I
doesn't
think-
that apply here?
Yes, I think Grimaldi even makes it stronger, but when I looked at all the cases that were cited, they all involved police interception. And none of them explicitly abrogated Santoro, Rivera, any of these other line of cases that deal with private individuals that are acting not at the direction of police. So I do think Santoro and those line of cases is still good law. I would argue that in those cases, the judge still has discretion to exclude it, certainly, but is not required to.
So when we consider a constitutional issue about suppression,
Yes.
we think about applying the exclusionary rule to deter police conduct. Does a statutory suppression remedy in the wiretap statute involve those public policy reasons behind it, the exclusionary rule?
I would argue that they're not, because typically a private individual, if they're not working at the direction of police, they're recording for some other reason. I would argue in this case that the victim was recording because she was afraid. She wasn't sure what the juvenile was going to do. He wouldn't leave her car. She just didn't know what to do. So that's why she was recording. There is no evidence that she was doing it for the purpose of assisting a prosecution. So I think the policy reasons there differ. I'm sure there is a scenario where a private individual is secretly recording and maybe there are grounds for suppression. I don't see that here in this case. As to the issue of the restraining order information coming in, the first statement where the victim testifies a little bit to a restraining order, I would argue that response on direct was not responsive to the prosecutor's questions. It was immediately, the prosecutor immediately redirected her to a different topic. No one brought it up again until cross of one of the juvenile's witnesses. But I would argue that was maybe even strategic on the juvenile counsel's part to not, highlight that evidence. No one's arguing that it should have come in. We didn't elicit it. We didn't try to elicit it. As to the information that came in during cross-examination of the juvenile's mother, I would argue that was proper impeachment. She was testifying to the fact that the victim was able to access notifications from the AirTag that was at issue. Juvenile's mother testified differently at a prior hearing, proper impeachment. Nonetheless, there's no substantial risk given that the restraining order itself wasn't admitted. There's lots of cases on this issue. There's many other issues in this brief. I'm happy to direct my argument to one of the issues. Otherwise, I can rest on my brief. All right.
Great.
Thank you very much.
Thank you both. It's a complicated case, and you've provided us a lot of assistance in deciding it. All right, we will hear one more case before our break. And that is Commonwealth versus Sanchez, number 24P 1408. And we got one more seat. Who's going to take it? All right, whenever you're ready, Counselor.
Good morning, Your Honors. Mary Miles for the appellant MISAEL Sanchez. Mr. Sanchez requests that this court grant him a new trial where the Commonwealth has failed to establish that the constitutionally infirm testimony as to his blood alcohol concentration produced by tests performed by another chemist was not harmless beyond a reasonable doubt. As an initial matter, based off of Gordon and Smith, in this case, Ms. Knowles testified that she reviewed the absent chemist's notes and her test results in the GCFID printouts and came to her independent opinion that his blood alcohol concentration was 0.207. As this, under both Gordon and Smith, is hearsay, and it was made for, and these tests were done for the, at the direction of the state police. And
what about the fact that the substitute expert witnessed the diffusion test, which, as I understand it, is what shows that there is some alcohol in your client's blood?
Well, first I would argue that she says the only reason that she remembered that she believes she saw the diffusion is because her initials were on the sheet. She doesn't actually remember anything about the test. And then she testified later that anything that the results of the diffusion had no bearing whatsoever on her independent opinion that the blood alcohol concentration was 0.207. So I would argue that whether or not the diffusion test comes under Gordon or Smith, the blood alcohol concentration and that's results of a blood level of 0.207 is clearly under Gordon and Smith a violation of his.
But was the substitute expert's testimony about the diffusion test results testimonial hearsay?
I think all she said was that I reviewed, I don't remember anything about the test. The only reason I know about the test is because my name is, my initials are on
Isn't that
there.
usually the case with an expert, with an analyst? They test hundreds of cases, thousands of cases a year. And when they come into court to testify, they may not remember the specific test.
But she didn't perform that test. She only observed that test. So I don't think she can't really answer any questions, right? Here's the issue is cross-examination.
Well, I don't get that. If someone watched the whole testing from beginning to end, why couldn't they offer, regardless of whether they did it, offer their own opinion? Yeah, I saw them do the test and put it in the machine. They put it in correctly, and then the machine popped out 0.207, and I saw that myself. And I mean, if they actually saw everything, I don't know why couldn't.
Well, yeah, I mean, but we're here talking about the diffusion test. She didn't observe anything to do with the GCFID test. She didn't even review it when I believe.
But the jury found your client not guilty of the .08 theory of OUI manslaughter.
Correct. I think you have to look at the jury instructions. The jury instructions specifically state, as when the jury is instructed on the third element of OUI, the judge says, next, I will define for you the alternative sixth element. That is whether the defendant is under influence of intoxicating liquor. You shall consider this theory whether or not you find the defendant has proved blood alcohol level of 0.08 or higher. Then the court goes into what is considered impairment and under the influence, and that is on, I believe, the last volume 5, page 86. And then they say that you need to look at other evidence in addition to the BAC. So I can't believe that we can necessarily say that the jury completely forgot about the BAC when they were considering whether or not the defendant was impaired. And we have to understand that we have to, all the cases the Commonwealth cites in their brief are either analyzed under Lattimore or substantial risk of miscarriage of justice that are both very, very differential to the Commonwealth. In both of those standards of review, we view all inferences in the light most favorable to the Commonwealth, all doubts in favor of the Commonwealth, or whether or not that evidence materially influenced the verdict. Here, the question is not whether the Commonwealth's evidence is sufficient to survive a Lattimore challenge, or whether admission of this, constitutionally infirm blood alcohol concentration was material to the verdict. It's whether or not the Commonwealth's evidence was so overwhelming as to nullify its effect on the jury's verdict of guilt. While, yes, the evidence here was persuasive. Yes, he had an odor of alcohol. Yes, he tossed unopened beer case out of the car. Yes, he was driving 93 miles an hour. But what we don't really have is any testimony of him drinking beforehand. We don't have any testimony that other than his speeding and the crash, his, driving was impaired. He went to McDonald's, no issue. I believe Ms. Courier, the eyewitness, said he was speeding really fast, but he wasn't swerving, he wasn't tailgating. So I would say that the evidence here is not so overwhelming that it nullifies the effect of this BAC evidence.
So what about the manslaughter? Just the simple manslaughter? Because the prosecutor's argument about the manslaughter, there wasn't any mention I saw about the alcohol. It was all about the tremendous speed and the nature of the neighborhood. So even if we reverse the OUI, what do we do with the manslaughter?
I don't think you can separate those two. I think those were instructed to the jury as one charge. At no point in the jury instructions does the judge say, you are to disregard the impairment evidence. You are to disregard the blood alcohol test. You are supposed to solely focus on the fact that how the defendant was driving. That was not instructed to the jury. So one can assume if we follow the court's instructions, as we should, that the jury considered that evidence. Further, the Commonwealth said in both the beginning of their argument and the closing of their argument that this case is about the defendant deciding to get into a car, drive 93 miles an hour with a blood alcohol concentration of 0.207. By the Commonwealth's own admission or own closing argument, that is what this case is about. I don't think you can separate one from the other. I think Guaman, the kind of ultimate case on OUI manslaughter, makes it clear that impairment, especially coupled with OUI, is relative or probative of whether or not someone is wanton in reckless conduct. Now, if again, Your Honor, if we were discussing a case where we're dealing with a sufficiency standard and, the blood alcohol evidence was, tossed for some other reason, or the defendant didn't object to it, so it's dealing with a substantial risk of a miscarriage of justice, there might be a solid argument that you could enter a conviction of lesser included of involuntary manslaughter. But I think because the standard here is harmless beyond a reasonable doubt, with all ambiguities and doubts resolved in favor of the defendant, we cannot say that the jury necessarily found the defendant's conduct wanton and reckless without admission of the BAC evidence. And I really think that's the crux of the case.
Did the Commonwealth have to prove that the defendant's wanton or reckless conduct caused the death, or that his impairment caused the death, or both?
No, I think the defendant's wanton and reckless conduct, the first element of that is his wanton and reckless conduct caused the death of Mr. Martin. And so, but at no point was the jury told that deciding whether or not the defendant's conduct created a high degree of substantial harm to another, they could not consider whether or not he was impaired, and in considering that impairment, whether or not his blood alcohol concentration was 0.207. I don't think a judge would, or the Commonwealth would agree that if they have an OUI manslaughter, they would want to separate out those two charges. That's the point of charging OUI manslaughter, so that the jury can consider the defendant's impairment and his decision to drive the way he did while impaired, that then creates the death of another.
Why isn't the evidence of impairment harmless beyond a reasonable doubt? I mean, why isn't the evidence very strong, even without the BAC?
Because we don't really have, I mean, so I cite Bohisian, Ranieri, and Grenier. And all three of those cases have the exact same or very similar situations and evidence that our case has. You know, in Bohisian, when she wanted to refuse the blood test, I think that the blood results came back with a .16.
So in some of the other OUI type cases, there's more evidence of things like field sobriety tests or breathalyzer tests or defendant's admissions. We don't have those here.
Correct.
Other than to the extent that his asking people to help him throw away the beer bottles is admissions. But we do have the other motorists see him speed past her at 80 miles an hour. It's on a straightaway with a stoplight. He's going 93 miles an hour. The victim's car is in the intersection and is T-boned by the defendant's car. The defendant, both two civilian witnesses, the motorist and the neighbor, smell an odor of alcohol in the defendant and see him trying to get rid of the beer bottles and throwing the beer bottles. The police officer smells alcohol on him. And then his medical records say he's clinically intoxicated. Why isn't that overwhelming evidence of impairment?
Well, I mean, it might be overwhelming for the Lattimore standard. That actually, I would argue that is overwhelming. But the issue in harmless beyond a reasonable doubt is not whether the evidence is sufficient without the BAC evidence to sustain the conviction. It's whether that had an effect on the verdict. Now, if we're dealing with impairment, the defendant has to unsafely drive his motor vehicle or his ability to unsafely drive his motor vehicle. The eyewitness didn't say he was swerving and wasn't crossing any lanes. He was admittedly going at a really high speed. But then the sergeant who did the accident reconstruction said he braked 3.5 seconds before the accident, which is larger, actually, or greater than the normal reaction time at night. So that would, with ambiguities resolved in favor of the defendant, would lead to the inference that he was able to operate his motor vehicle safely. Second, all the cases that I cite, Hallinan, Ranieri, Bohisian, they all had the odor of alcohol, swaying on the feet, failing field sobriety tests. Some of the cases even had the defendants admitting that they had alcohol before, none of which is not present here. The one piece of evidence that is present here is those hospital records. However, those hospital records, it says clinically intoxicated to clear cervical spine. But there's no evidence or expert testimony as to what clinically intoxicated to clear someone's cervical spine means. Clinically intoxicated is not going to the ultimate issue, right? That's why an officer is allowed to testify that someone is intoxicated but not impaired or under the influence. So while I would say that under the Lattimore standard and viewing the evidence in light most favorable to the Commonwealth, does the Commonwealth win on that argument? Probably. But that's not the standard before the court.
Would you agree the evidence is overwhelming that he had some alcohol?
Yeah, I can say that. If we're clinically intoxicated, we're not really quite sure what that means. I mean, if someone has one beer and they can't sit still to clear C-spine, does that mean someone's impaired to drive? I'm not sure. But yeah, I mean, I guess we could possibly say that he had some alcohol. With the odor of alcohol, sure. But can we say that the BAC of .207, 2.5 times the legal limit, didn't have an effect on the jury's decision to convict the defendant of OUI manslaughter? I'm not sure that we can say that. And so whether or not involuntary manslaughter is a lesser included of OUI manslaughter or not, the BAC results go both to the third element and to the sixth element. And the jury was not instructed to segregate those two charges out so that they only considered his conduct in driving for wanton and reckless and only his conduct in drinking for impairment. As such, I would urge this court to grant Mr. Sanchez a new trial. I would agree with the last point of the Commonwealth. I would agree that given that they didn't failing to check off the per se doesn't necessarily mean they found him not guilty of per se. I would agree that the Commonwealth could go forward both on involuntary manslaughter and per se if a new trial is ordered. If Your Honors have no more questions, that's it. I'll rest on my
Just
brief.
writing down what you just said. It was really helpful.
Thank
You very much, Counselor. All right, we will hear from the prosecutor. Whenever you're ready.
Thank you, Justice Ditkoff, and may it please the court. Nelson Brett, Assistant District Attorney, Hampden District, on behalf of the Commonwealth. I think just to start maybe with two framing points, if I may. One in response to the last rhetorical question that my learned colleague opposite asked. I think we can be sure in this case that the jury rejected the BAC evidence as presented, because if you accept the BAC evidence, you convict the defendant of the per se theory, which they did not do. So in this case, I think we can be confident.
Well, we know they weren't convinced beyond a reasonable doubt that he had a .20 BAC, but could they have possibly found it more likely than not that those results were correct?
I don't think on the facts of this case that you can say that. I think that it was really an all-or-nothing battle in this trial over the validity of the BAC evidence. And again, I think the harmlessness beyond a reasonable doubt standard is a very fact-specific one. And in this trial, a lot of energy was expended by both sides, particularly by the defense, on calling into question the validity of this evidence in the Commonwealth and defending it. And if you accept the validity of the blood test, you convict the defendant. I think that's the only way to look at how this trial played out. And so I think that in these circumstances, this court can be confident that given how the verdict slip came back, the jury didn't accept that evidence.
Can I ask a question on the jury? Oh, sorry, go ahead.
That's a little bit in tension with your argument that you can retry on both, because that's based on the idea that some jurors might have believed that the BAC was over .20 and some didn't, and so as a soft transition state, they went on to the next thing. So how do we know that none of the jurors believed it?
So I think the tension dissolves because if this court is inclined to think that that this was a background consideration of the jury, and you can't say to a moral certainty that the jury didn't consider it, that's what triggers consideration of our alternative argument. And then under the case law about our alternative argument, this is in the anti-penultimate paragraph of the Commonwealth's brief, pages 51 to 52, the Nemec case and cases cited in the Nemec case. Under that case law, when you're looking at what are the retrial possibilities, the SJC is very explicit that failure to check a box is not acquittal.
I get it. It's got to be one or the other.
Right, and so again, I agree with you. This court is deciding if it's one or the other. The Commonwealth's position and our primary position in our argument is that it is the former. It is that under the circumstances of this case, as the evidence came in, as it was argued, as the jury was instructed, it's clear that the jury must have rejected the validity of this BAC test, and therefore the conviction should be affirmed because they convicted under the theory that didn't require them to accept the BAC test. If the court doesn't buy that argument, then we're on the fallback on ordering either entry giving the Commonwealth the option of retrial or entry of a verdict of manslaughter simpliciter.
Could I ask this, with respect to the verdict slip, does it matter, or should it matter to our consideration that the verdict slip lists the theories of manslaughter, OUI, disjunctively, as per se or impairment? I understand that the judge instructed correctly that the jury could find both. The verdict slip says something else.
I don't think that matters, no. And again, I would advert to the Nemec case and cases cited there, especially Carlino, 449 Mass 71. These are mostly first-degree murder cases with different theories available to the jury. And those are very clear that the sort of potential vagaries of the verdict slip don't matter for the proposition that failure to check a box is not acquittal. Again, emphasizing in response to Justice Ditkoff's question, which I completely understand, that is the Commonwealth's fallback position if this court doesn't buy our argument that, again, as I say, as this case was tried and as things came in, the jury must have rejected the BAC evidence. I see maybe questions about it. So I just wanted to make a second framing point, if I may, for consideration, which is, I think, in some ways, the most helpful cases for reasoning by analogy for the harmless beyond a reasonable doubt analysis in this case are the post-Melendez-Diaz cases cited on pages 37 to 38 of the Commonwealth's brief. So these are Lazinski, Lodholt from the SJC, and then Sullivan, Marte, and to some extent Wellbrooks from this court. And then I'd also add a case that's not cited in the brief, for which I apologize, but from this court, Commonwealth v. Encarnacion, 105 Mass Appellate Court 46. I know, Justice Grant, you were on that panel from 2024. That's a post-Guardado case on, again, being analyzed under harmless beyond a reasonable doubt, about deciduous testimonial hearsay about failure to have an LTC. I think all those cases are helpful because, and I would argue the OUI context is a stronger one for the Commonwealth than those cases, because when we're talking about narcotics, when we're talking about ballistic certifications, when we're talking about lack of evidence that the Commonwealth system has an LTC record, there is no alternative theory by which the Commonwealth can prove that. Whereas in the OUI context, as we have here, and as I attempted to emphasize in my first point, we do have two separate theories. And again, as this case came together, it was really an all-or-nothing proposition on the jury accepting the BAC evidence with respect to the first theory. And again, looking at, to take an example, Lazinski, you actually had a toxicology report in Lazinski about fentanyl in a victim's blood system that shouldn't have come in, and everyone agreed it shouldn't have come in under the Confrontation Clause, and agreed it's a little vague in the opinion, but I shouldn't say vague. It's a little equivocal, but it is clear that they're analyzing it under harmless beyond a reasonable doubt. And they say that it's enough that 5 witnesses testified that the defendant was distributing fentanyl patches. And they even say, just to refer to my learned colleague's point, that all inferences are to be drawn in favor of the defendant in this analysis. In footnote 7 of Lazinski, the SJC says, yes, it's possible that the jury could have discounted all 5 of those witnesses, but we think it's very unlikely. So I think that kind of sets a backdrop for analysis of how to draw inferences in favor of the defendant in these cases. I just refer briefly to Lodholt as well. There were only 2 police witnesses to say that this was in fact the ammunition that we found on the defendant, and it was in fact this type of ammunition, and that was held to be enough in Lodholt to overcome the Commonwealth's burden under harmless beyond a reasonable doubt analysis, despite an erroneously admitted ballistics certificate. So I think, again, as I think Justice Grant mentioned towards the end of my colleague's argument, here we have the 2 civilian witnesses, we have the incredibly inculpatory behavior by the defendant, we have the hospital record, and we have the police witness who, in addition to smelling alcohol, sees the cold beer in the case and sees...
Speaking of the facts, I wanted to ask you about why you wrote your brief a certain way. The statement of facts section of your brief starts by talking about the neighbor hearing the crash and running to the scene. I assume because he's the first witness who testified. Then you talk about the motorist seeing a black car speed by her, and that happened previous in time. So I was really confused when I read your statement of the facts because the facts were not in chronological order. It was as if you gave me the pieces of a jigsaw puzzle and said, here, Judge, you figure out what happened.
I apologize about that, Your Honor. I agree with you that I usually strive to do that in chronological order. Yes, so I will certainly take that to heart in the future. But I certainly would emphasize the point you made again to my colleague that I think her fellow motorist testimony about the defendant's driving is a very important probative piece on the recklessness element. I don't want to preempt any questions, but I know there was some discussion in my colleague's argument about the ability of the fact finder to take impairment into account in assessing the recklessness element, just for purposes of the Commonwealth's fallback argument about the validity of a manslaughter as a lesser included offense, regardless of the court's determination of the BAC evidence issue. And I think I would make a few points on that. Again, I think Justice Ditkoff, you mentioned to my colleague that the prosecutor in his argument was extremely careful in not mentioning the impairment evidence whatsoever in discussing recklessness at page 102 of his closing argument. And there was also no instruction suggesting that, as my colleague acknowledged, which does happen in some cases. The Dyer case, which is cited in the Commonwealth's brief, included such an instruction. And then there have been cases, admittedly under more Commonwealth favorable standards of review, like Faloma, I would mention, where the prosecutor actually does conflate impairment and recklessness quite confusingly, I would say, in the closing arguments, and the SJC has nonetheless upheld convictions in those circumstances. Granting that this is a much more defendant-favorable standard of review, I would nonetheless argue that the risk of conflation here is just very low, especially when considering how the jury, again, as we argue, clearly didn't fully buy the BAC evidence.
I have a question for you about this wanton or reckless. Part of the defense theory at trial was that it was possible that the victim had pulled out into the travel lane against the traffic light, and so the accident wasn't totally the defendant's fault. In your brief, you sometimes refer to wanton or reckless conduct, and sometimes to wanton and reckless conduct. So if somebody perceives a danger and doesn't care and continues anyway, that's wanton. If they don't perceive the danger because they're not paying attention, that's reckless. Does the Commonwealth have to prove both?
I believe that we do, and I should have a firmer answer for you. But yes, that is my understanding of the standard, that is wanton and reckless conduct for involuntary manslaughter. I'm not sure.
You know what Wolanski says?
Potentially not the way you're asking me that. So I will revise my answer to wanton or reckless. I suppose my real answer, if you'll forgive my ignorance on that question, is that it probably shouldn't matter in the facts of this case, given the extreme speed in a settled residential area in the dark. I don't think there's a jury in the Commonwealth that doesn't find that this is wanton and reckless, or wanton or reckless beyond a reasonable doubt. I believe those were all the points I wanted to make, and if the court has no further questions, the Commonwealth will rest on its brief.
All right. Thank you, Counselor. They're not exactly giving you easy ones, but we appreciate both of you. It's really helpful for us. All right. So that's 4 cases. We're going to take a break. It'll be about 15 minutes, and then we'll hear the last 2 cases. I'll remind all the interns that if you stick around to the end, we will come down and talk to you afterwards, so I hope you will do that. We even have a few empty chairs. All right, so I'll call the fifth case of the day, adoption of a child, number 25P 1168. I'll remind the parties that the case is impounded. We won't name any of the civilians. We'll use terms like child, father, mother. Counselor, whenever you're ready.
Good morning. May it please the court. My name is Alan Campbell, and it's my privilege to represent Father in this appeal. Father is asking the court to vacate the decision terminating his parental rights, or in the alternative, to remand with an order for the juvenile court to enter an order regarding post-termination and post-adoption visitation. Now, to be clear, Father is not arguing that he is fit. Rather, he is arguing that termination was not in the child's best interests, given that the child is in a residential school and that there was a lack of evidence that he would become adoptable. As a primary matter, this argument is not waived. There is no requirement that a party point out evidentiary flaws in their opponent's case before the end of trial. That would be like requiring a defendant to make a motion for required finding of not guilty before the Commonwealth had closed so that they could fill any evidentiary gaps. The Commonwealth, rather, the DCF bears the burden of proving their case. Part of their burden is the plan, and the court is required, without anybody asking them to consider the suitability of the plan.
Was your client required to raise the question about the adoptability of the child?
He was not, because that's when the judge is considering the plan, and the plan is adoption. The court has to consider whether or not this is a plan that can actually happen.
Well, is your client's position isn't that it can't actually happen if his parental rights are terminated and there's no contact? That can happen, right? The argument is that your client can't be readily adopted, and therefore that changes the analysis. Is that the argument?
Well, it's not my client. It's my client's child.
Child. Sorry. Yes, you're right.
Well, yes. The crux of the argument is that because the child can't be adopted, the rights shouldn't have been terminated. But the reason that he certainly could have called witnesses or experts as to the likelihood of adoption. But again, DCF bears the burden of proof. Their case was that it's in this child's best interests that rights be terminated so that the child can be adopted. As part of that, in proving that the best interest, they have to prove that their plan is possible. And DCF argues in their brief that we didn't present any evidence as to the feasibility of it. Neither did they, and nor did the court make any findings on this. There are, I think, 6 findings in this section on the adoption plan. It's essentially the goal was changed to adoption, the kid was placed here, the kid was placed here, this is what the kid's doing, this is what they hope to have happen. No findings whatsoever as to the chance of a child who's 10 years old, who's been institutionalized for the last 3 years, without them being able to even...
Let's take a more ordinary situation. Just, infant child, no health problems. Does DCF have to prove the child's adoptable affirmatively?
I would say that there is some institutional knowledge that a young child without any special needs is likely to be adopted. I think that's an assumption that the court could make.
So what institutional knowledge does a juvenile court judge have on the adoptability of this child?
I would say essentially none.
Well, how do we know that? I mean...
Well, we know that there was a case, Osborne, that there was some evidence entered at trial, and that was in the year 2022, that there were 74 children with moderate to severe special needs that were placed. The appeals court, in discussing that, this court says, there's nothing about these, this is not sufficient, that there was no information as to the terms, what moderate or severe special needs were. They didn't even go into what the special needs were. And in Osborne, they reversed the termination in part because of that. So, a statement of facts from a non-published decision is not a substitute for evidence as to the adoptability of this child. And remember, this is a...
But if the judge's just institutional knowledge is a substitute for evidence, then how do we know, we're not juvenile court judges, I mean, a juvenile court judge probably sees how often children like this get adopted all the time because they have to do the adoptions.
I would doubt that that is true, given that this is not a typical child. That's why it's a different situation. This is a 10-year-old child who has been institutionalized with moderate to severe ASD. The DCF has not even been able to place this child in 3 years. He is required to have been institutionalized. In the facts talking about the child and the progress he's made, and he has made some progress, the big kudos are that he's starting to use words and he's toilet trained. This is not a typical child. The red flag should have been going up all over the place for the court to consider whether this child is actually going to be adopted. The court has to...
Could the juvenile judge take sort of judicial notice of the institutional knowledge that a child who's free for adoption is more adoptable than one who's not?
Yes, while that is certainly true, it's a logical syllogism, though. It's true because of the terms you've used. It's not impossible that this particular child will be adopted. Some children with extreme special needs get adopted, but when the court is finding out whether it's in the best interest for this particular child to terminate his parental rights so that a plan can happen, the court has to consider what is the likelihood of that happening. And in the cases, I'm not talking about my personal experience, but
the question for us is, what happens if the parties don't do that? If neither party, unlike in Osborne, neither party presents any evidence about the likelihood of adoption, does a judge have to say, I can't make a best interest finding? If there was not enough evidence of unfitness, of course, the judge would have to.
We actually have an answer of that. And the answer is the party that bears the burden loses. That's what having the burden of proof means. You have to provide the proof. They didn't do it. They didn't meet their burden. It's a simple, straightforward argument. You know, if both sides put evidence in, then the judge has to decide between it. But when nobody puts forth evidence, the party that bore the burden loses because they didn't meet their burden.
Were there other bases on which the judge could have determined that it was in the child's best interests to terminate the father's parental rights besides this particular question of exactly how adoptable the child was or wasn't? For example, whether the father's roller coaster, as the judge put it, experience with substance misuse and his presence and absence intermittently in the child's life and responsibilities played against the child's need for stability, as any child would benefit from having
Every
stability.
child deserves, is entitled to stability. Father's roller coaster ride with drugs and alcohol does not impact the child. We're not asking that the child go back to father. The DCF would still have permanent custody. The child would still be in his exact placement. There's no evidence that father has ever tried to disrupt the plan. And in one of DCF, in arguing against my visitation argument, says if father misses a visit, there's no impact on child. So what you have on one side, and we're sort of conflating issues, but if you have on one side, child enjoys the visits, they go well, there's no evidence that father was ever inappropriate or the child didn't love the visits. That's what you have on one hand, weighing in father's favor, and on the other hand, you have absolutely nothing if he misses the visit. So you're weighing a chance for a child who's in an institution to have every month or every other month or whatever the schedule is, to have one extra hour of joy in their life versus not having that. There is no downside.
Is there some evidence that, and I'm just trying to tease this out a little bit, is there some evidence that the child was unhappy about the lack of a visit or a failed visit, and also evidence that the father periodically did not visit the child?
The evidence was that, remember, this is a child with severe ASD. If the visit didn't happen, it had no impact on him, no negative impact on him.
There was no instance in which the child cried because there was a visit, it didn't happen? Am I remembering that incorrectly from the record?
I'm trying to run through it, and I'm at a little bit of a hindrance because wasn't the initial counsel who wrote the brief. If it did happen, it was one very limited instance. I mean, the case was going for several years, so it's possible that once it happened. But there was no it was not in the findings that the child was unhappy or suffered because of the visits. And again, conflating issues. In finding 222, the court found that mother and father were generally consistent at attending visits and appropriate during visits. There's then a list of the visits. They did miss some visits. Every one that they attended, they were.
There was a period of months that they missed visits that were
Well, yeah,
dependent
I
upon
don't
their
want
proof of
to, I'm not
sobriety.
talking, I only mentioned mother because that was in the finding. There was a period where father missed 7 months of visits. To put that in context, his parental rights had been terminated, and he was told he could only have a visit if he presented a clean urine screen. If he could present a clean urine screen, his rights wouldn't have been terminated. That is essentially telling him you can't have visits. You know, he had years to sober up, he couldn't. And then
Wait,
say, okay, well,
so
you can see
are
your
you,
child.
are you suggesting that if you, that we should order that he be allowed to have visits even with non-clean urine? Is that the remand you want?
Yes, to whatever the terms of the visits that he had for years, that they always went well, and there were no clean urines were required for those visits. Adding on a requirement to a person, and I don't want to sound like I'm disparaging my father, but my father's client suffers from drug addiction. He cannot become clean. That is why he's an unfit parent. To then say you're only going to have a visit if you can get clean it almost makes a mockery. If he can get clean, he would be a good parent. So requiring him to get clean for a visit when he's not shown up at visits under the influence, he may have missed the odd visit because of his drugs, but his drugs never impacted any of the visits that he attended.
And the fact, am I understanding your argument correctly, that even if the judge except for the purposes of argument, that the judge made a correct finding that there was no strong bond between the child and the father. Father loved the child. Father made all efforts that he could to maintain a bond, but the child did not have a strong bond with the father. It is your argument that even in that situation, it's still in the child's best interest to have the father be able to have contact and potentially not have his rights terminated because there could be an hour of joy in the child's life.
There's two arguments. The termination argument is really focused on he shouldn't have terminated because of the lack of evidence that the child would ever be adoptable, so that you'd be creating a legal orphan. As to the visits, yes, this is a very unusual case where you have conceivably have a case where there isn't a strong bond between the child and the father because of the child having ASD, where even if there isn't a strong bond, the child still benefits from the visits. There is nothing in the record to suggest that the child doesn't benefit from visits. And especially, and again, this is assuming you disagree with me on the termination question, especially in the post-termination period, why should we have a child stuck in an institution, he'll be there for 8 more years, and then switch to a different institution possibly, or to, wherever we're released? Why is it not in that child's best interest to have somebody who will consistently visit with them and bring them some joy? These cases are about the child's best interest. Once you get past fitness, it's about the best interests of the child. It's not about the best interest of the court or the DCF, because there is some mention of the father could file for R&R. This father will never win an R&R, and the R&R wouldn't impact a child. So when you look at the best interests of the child, you have the option to provide this child regular visits with somebody that he's known him for 10 years, he can continue to know him, or he doesn't have that. And how is it not in the child's best interest to have those visits?
Most of the cases that I can find where we have second-guessed a juvenile court judge's decision in a case like this involve situations where the child, who's represented by counsel, agrees with the parent that there should be visitation or that there's a bond or that the relationship shouldn't have been terminated. And I'm thinking of Gertrude and Varnell and Franklin. Do you have so does it rise or fall on what the child wants or what the child's lawyer says they want?
It does not. Obviously, the court can consider it. Everybody will have a different idea of what the child's best interests were. If we did what the child wanted, we wouldn't need trials. We'd just have the child's attorney state their position, and that would be it. So please feel free to consider it, but it is not determinative. And in everything in child's brief, they also don't explain why it is not in this child's best interest to have, again, getting past the termination onto the visits question, there's no explanation of why the visits are harmful to the child and why father shouldn't have them. And then my time is almost up. Unless there are additional issues, I will rest on the brief.
All right. Thank you, Counselor. We'll hear from the department next. Whenever you're ready, Counselor.
Thank you, Your Honor. Good morning, Your Honors, and may it please the Court. Zachary Edelman on behalf of the Department. This case is about a trial court that providently exercised its discretion in finding that parental termination, the termination of parental rights was in the best interest of child. It reached this determination based off of the roller coaster that father had on child's life. And it's a sad case about a father who is unable to overcome substance abuse disorder, but that substance abuse disorder led to instances whenever there were relapses in substance abuse that led to instances in which father acted against the interest of child. And so you have examples of this active obstruction of child's well-being for a child who needed many services while growing up that he was unable to get because of father's neglect and obstruction, developmental, educational, and medical. So for example, in November 2022, father affirmatively declined a referral for services for child because, quote, child gets it at school. That was at the same time, that same month, that father refused for the third straight month to begin methadone treatment, despite telling DCF he planned to do so and could not provide DCF with a drug screen.
How does the father interfere after the removal?
Yes, Your Honor. So,
if he does.
So in terms of active interference at that time, father did not actively interfere. Post-removal, what we do have is that at the same time, the same pattern of relapses leading to potential actions that could harm child, for example, the 7-month stretch post-removal in which father does not visit child. And to correct the record a bit, although for 5 of those months, father was required to have clean drug screens in order to visit child. As of October, the parental termination at that point had been revoked, and father was able to visit child just if he wanted. There were no conditions, and father did not visit at that time. Father then again missed in November, although he excuses that absence based off of the inability to confirm the appointment. And this is relevant. This failure to visit is relevant because we have 2 possibilities here. One, there is no, in the record, there is no strong, significant bond. And that would be what would be required for father's argument that a bond could justify overturning the trial court and finding that the trial court abused its discretion. We don't have anything.
From the child to the father, or does it matter?
Yes, it does. It does matter there. It's the child's bond with the father, not the father's bond with the child. And every case that father cites that talks about bond is always talking about the child's bond with the father. And this makes sense based on the best interest of the child standard. If we had a different standard, then one could assume that every time there was an appeal, the parent did desire connection with the child, but what we're looking at in terms of the best interest of the child is the child's connection to the parent. And
so what do you say to the father's argument that even if there is no void that's being filled by the father's ongoing contact, it only is value added when he does have contact, and therefore it must be in the best interest of the child? And if I'm phrasing incorrectly, it's not intentional. But if that's the argument, what do you say to that?
Well, Your Honor, I would point back to the question you asked on the facts on the record, whether there was a time in which child was caused some distress by a visit, and that was a virtual visit that father attended virtually instead of in person, at which led with child crying based off of him saying he missed father being there at that time when mother was there. There's no other evidence of anything with missing, but the fact is here that we have a worry that where the court found, and it's uncontested, that father has substance abuse issues that are likely to continue to a near degree of certitude into the future, that father will have other times of relapse where he will miss appointments and visitations for long periods of time. If there is any bond, that can lead to this significant distress or distress over time. And so this small amount of, excitement during a specific visit, which the court noted that below at findings at 250 that, and then the transcript, at the transcript at 250 to 251, that while child is excited to see his parents, he has no problem separating from his parents at the end of the visit, and there was no testimony that him seeing his parents was any different from, quite frankly, anyone else that he sees on a daily basis. This idea that this would be some great value add isn't really there. And this court, in a number of unpublished opinions, has determined that just examples of children with happy visits does not count as a significant bond to overcome the need for permanence. And that's, for example, Wyanetta, Zikora, Vicky, and Joy all had excitement at seeing a parent that was not considered the significant bond that could overcome this need for permanence.
Do we know anything about why the adoption social worker didn't testify, and can DCF meet its burden without the testimony of an adoption social worker?
Your Honor, I don't have information as to why the adoption social worker did not testify. In terms of the burden, yes, the burden has been met here. There is an adoption plan that has been set forward that's a thorough adoption plan about the steps that are going to be taken to lead to adoption. In this case, father disputes that adoption is likely for the first time on appeal. First, the department would say that this argument is waived. This argument was not made below, and as the questioning with my colleague went before, there has to be some sort of ability for the judge below to determine whether and to consider just if there's no argument on the facts of an adoption plan that's uncontested, that adoption might be at least potentially likely. What we also have here, though, is we actually have...
The adoption plan here wasn't uncontested. The father moved to strike it, right?
The father moved to strike it on unrelated grounds that were unrelated to the possibility of adoption. And what we do have here is we have a case with very similar facts in Gertrude, in which a similar argument was made for the first time on appeal. And the argument was made for the first time on appeal that the problems of having a child not have a parent would outweigh any adoption benefits because adoption was so unlikely for older children. And there's this assumption in the record that older children are less likely to be adopted. And in the Gertrude case, the court first said the department did not argue that this was waived, so we're going to consider it, thus showing that this could have been an argument that was waived, but then says, looking at the facts on the record, there's no record evidence here that adoption is unlikely. So this court in Gertrude then showed what the burden is, and the burden is you say an adoption plan. If it's objected to, then the department has to show why that adoption plan is likely. But if it's not objected to, the question on appeal is, what does the record evidence show? Is there record evidence that adoption is unlikely here? Now, in terms of whether adoption is likely, my colleague brings up the Osborne case, which is an unpublished opinion. I'll note then in the Osborne case, we have a very different set of facts than the facts here. In the Osborne case, we have a nonverbal child, a non-potty trained child, who we know is going to be need lifelong care, and that's part of the findings. In this case, post-removal, child has flourished at the Higashi school, can now speak, is potty trained, has sung in concerts for the Higashi school, is going on weekends to visit his sister, that's shown in the record, and being successful, has flown on planes. This is not a case like the Osborne case, and there are many cases, and we cite these in our brief, in which children with developmental disabilities are adopted, and the department takes pride in being able to have children be adopted. So this idea that there should just be an assumption that adoption is unlikely here is not a proper one that this court should accept. Moreover, in terms of visitation, this is a bit of a double-edged sword that I was getting to. Either we have an issue where there is no benefit to visitation, in which case it should be up because there is no significant bond, in which case we should leave this up as the trial court did to the department to determine what is best for child and to determine if a visit is appropriate at any given time. The department would be in its rights to determine that father should not get a visit if, for example, father is at that time using substances. If on the other hand, there is some grand benefit because there is some significant bond that child has with father, then visitation could be harmful if ordered if father then, as the court found, did not visit for long periods of time because father happened to relapse at that time. So you have this double-edged sword here where either there is no bond, in which case there's no reason to find that the trial court abused its discretion, or there is some significant bond, in which case there's even more reason to think ordering visitation would be an issue. And I'll rest on my papers unless there are any other questions.
Goes by fast, doesn't it?
Yes.
Thank you, Counselor.
Thank you.
We'll hear from the child now. Afternoon.
Good afternoon, Your Honors. May it please the Court, Peter Heffernan on behalf of the child. Your Honor, we are asking the Court to affirm the orders of the Juvenile Court because the evidence of father's current and likely future unfitness was clear and convincing, and because the trial judge's determinations with respect to child's best interests were well within the reasonable alternatives available to the Court. I did want to address what the Court order says. We talked about father being precluded from visitation with child. The trial judge's order does not preclude father's contact with child. There's no order saying father cannot visit child. The court left the decision as to father's contact pre-adoption to DCF and post-adoption to a future family. There is no evidence in the record that father took any steps to request that visit, to ask DCF whether they would exercise their discretion and permit him to visit. What we do have in the record is a 7-month period where the court had ordered DCF to provide monthly visit, where father did not avail himself of any of that opportunity to maintain his relationship with child. And so what we have with respect to father's relationship with child and child's relationship with father is a tenuous bond between father and child. And as the appeals court has recognized in Gertrude and in Nancy, that termination of parental rights can be a necessary step in easing the way towards permanency for a child. And father is asking this court to vacate the termination decree so that he can have his occasional visits with child at the program, which he is already entitled to, because we don't know that the department has said, no, we're exercising our discretion and you are not entitled to that visitation. We don't know that. It's not in the record. But he has the right to ask for that. In exchange, on the other side of the ledger is the child's right to permanency. And what that involves is the department's quest for a family. And the harm to the child of vacating the TPR or not having the TPR is, one, it creates obstacles to recruitment for families because it is, there's a significant legal risk to families looking to adopt because there is a lot of process that has to happen prior to that child being freed up. That's one harm. The other harm is the length of time that the process takes. My argument is that my client should not be treated differently than other children based on this record. As counsel for the department just detailed, child is functioning at a high level for a person with Asperger syndrome. The failure of any trial counsel to raise adoptability or lack of adoptability as an objection at trial, which they did not, deprived the other counsel and the court to directly address that. The issue was not raised. My client is doing very well where he is. The department is continuing its efforts as it detailed in its adoption plan. And with respect to father's ability to have some contact with child, he has the right to pursue that as things stand today. If there are no further questions, I would rest on my brief.
All right.
I meant to say to Father's Counsel, thank you for the 16L letter.
Yeah, and thank you for stepping in, too. That's really helpful. So thank you all. These are always difficult cases. Mr. Ellman, could you step up again? So I know this is your first time here. Is it your first time giving an oral argument?
It's my first appellate oral argument.
Well, there's a story I heard of some paratroopers in World War II going to the tomb of Napoleon Bonaparte and being told he was the greatest soldier of all time, which they all reject on the grounds that he never did a parachute drop, so he couldn't possibly be. And I'll assure you that every appellate attorney feels the same way about having an oral argument, and that now whatever you do in your career, you're an appellate attorney, and we are happy to welcome you to the ranks of our appellate attorneys, and I hope your career will bring you back here many times.
Thank you, Your Honor.
And you made very good eye contact. It was a very persuasive.
Thank you.
All right, home stretch. Call the last case, Old Ironsides Energy LLC versus Marsh and McLennan Agency LLC, number 25P1075. Whenever you're ready, Counselor.
Thank you, Your Honor. May it please the Court. Margaret Upshaw for Old Ironsides Energy LLC. This case is about whether Old Ironsides suffered any harm above $0 from defendant's serious professional negligence. On appeal, defendants don't seem to be contesting that Old Ironsides only had to show that some amount of the attorney's fees was reasonable, not the full $20 million+. So the only question here is whether we have evidence showing at least some reasonable fees. We clearly do. At minimum, we know that Cleary responded to 2 SEC subpoenas by reviewing and producing tens of thousands of documents, and that Cleary attorneys worked to prepare Old Ironsides partners and employees for at least 10 SEC depositions. That work was not optional, and it was not free.
How do we know that? We know there were subpoenas, but I didn't see anything in the record that said that Cleary did the productions or even did the preparations.
Your Honor, I think the key place to look is the testimony, the deposition testimony of multiple Old Ironsides partners, the chief compliance officer, and the chief financial officer, all in the summary judgment record, where they describe both the production of the documents, that there were tens of thousands of documents. The chief financial officer testifies that he worked directly with Cleary attorneys to, kind of guide them through the documents, explain what was there.
Where, could you tell me where that was? I looked at every page, but I certainly didn't read every page.
Absolutely, and let me give you some citations, and then we cite to much of the deposition testimony in our brief as well, but let me give you a few citations on this question of the documents. So this is the Delmore deposition, and in particular, I would point to page 194, record volume 2. And Delmore there is testifying that he was very closely involved in the document productions, and so it was his responsibility to work with Cleary to collect and to identify and to produce the documents. That means that that he had personal knowledge of work that Cleary attorneys were doing.
Yes, when you say volume 2, page 1, is 194 the page of the deposition transcript or the page of the record?
No, Your Honor, it's the joint appendix citation.
Well, that's not, there's nothing on there. It's just the...
errata sheet and a signature.
Oh, let me make sure I have I apologize, Your Honor. I'll pull it up here and see if I can find the proper page for you.
Or the O'Neill.
I would also point to the Haney deposition. It's volume 2, page 325.
where she also testifies to working with Cleary to produce documents. And let me just make sure I have. So I'm on the Delmore deposition. It's page 357 of the deposition, the September 20th, 2023 deposition, JA 294.
294.
Let me make sure I have the right volume.
So 294 is the Delmore, page 355, deposition.
The Delmore deposition, correct. And it's page 357 of the Delmore deposition. It's JA 294. And I apologize if I'm mixing up the volumes, but I believe it should be volume 2. Is that? I just want to make sure I'm guiding the
Yeah, no.
Okay, I'm sorry about that. And so he's testifying here, what was your role with respect to production of documents? Just determining what documents answered the request, providing them to Cleary, speaking with Cleary, letting them know really what the documents were. And so he's testifying, I worked directly with Cleary to produce the documents. And the jury would hear that testimony, and then it would hear testimony that tens of thousands of documents were ultimately produced to the SEC, along with the subpoenas mandating the production of the documents. The only question at summary judgment was whether a jury could reasonably find that something like that activity required at least some Cleary attorney hours, and that Cleary had to be paid for that work. And we think the answer is certainly yes. The same is true for the depositions. That's another concrete example of work performed.
How would the jury compute damages? Would the jury know, oh, Cleary, they're a really good law firm, and oh, they must charge at least $1,000 an hour? How would the jury know any of that?
So, Your Honor, there are Cleary rates in the record, and that is, so it'll be page 262 to 263. There are Cleary rates for the core team, for attorneys. So you have, two partner rates, you have associate rates in the record as well. So there's evidence on the rates, and then there's testimony about the reasonableness of the rates and the fact that the rates were very similar to the other law firms that the old Ironsides partners interviewed. That goes to the rates. And then the other piece of the equation is the work performed. So there's, for example, the document production. There's also the depositions, which take time. Even if you were just to look at, okay, there are at least 10 SEC depositions. Each deposition lasts approximately a day. There's testimony on that, too.
Who testified that they were prepared by or had a Cleary lawyer with them at one of the SEC depositions?
Yes, Your Honor. So on the depositions, I think that the testimony is, so there's an interrogatory response, first of all, that explains that the Cleary attorneys prepared them for the depositions, and ROG responses are certainly competent evidence at summary judgment. There's the subpoenas for testimony from the SEC are also in the record directly, so we know that these were mandated, required depositions that these individuals had to show up at. And then Greg Marzano, for example, the 30B6 deposition, he testified that he was deposed by the SEC, and so he was prepared by Cleary.
Well, then did he say he was prepared by Cleary? That's what I didn't see.
So, Your Honor, I think that goes with the ROG responses, and so our interrogatory responses explained that they were prepared by Cleary, and it's very clear that these depositions occurred, and of course, Old Ironsides had representation at those depositions, and it prepared its clients for those depositions.
Is an interrogatory response that's hearsay, that's verified hearsay, is that something that can defeat summary judgment?
But Your Honor, I think that the fact that, for example, Mr. Marzano would have been prepared directly by a Cleary attorney means that he had personal knowledge of that work. And he describes the depositions at length in it's 227 to 228 of the appendix. It's volume 2, and we can go there if helpful. So he's talking there about the depositions of all of the managing partners, of the different employees, of a former employee, and we know that those occurred, that they were working with Cleary both to defend those and to produce the documents. And so I think that that evidence is very much competent evidence that a jury could consider in concluding that Cleary had to dedicate at least some amount of time to this work, and that Old Ironsides had to pay for that work. And that's the only relevant question at summary judgment. The question is just whether there's a genuine dispute of fact as to whether at least some of the fees were reasonable. I think it's really hard to answer that no. If you take a step back, this was a 4-year SEC investigation where I don't think anyone is disputing that Old Ironsides actually paid its attorneys to represent it, or realistically that Cleary actually
how's
did
the jury
work.
supposed to figure out how many hours you would spend to do document responses, or how many hours you'd spend to prepare a deposition?
So, Your Honor, I think that, just to be clear on the standard here, I think the jury only has to find, for example, that a deposition took approximately a day, and say they round down to 6 hours, and that required Cleary time, and that would mean more than 0 damages. So we shouldn't lose outright and lose the chance to present that evidence to the jury. And that's the basic submission here. Now, there's testimony already in the record. Sean O'Neill testified that he approximated his deposition lasted a day. Of course, if we go forward to trial, we'll bring our witnesses up to the stand and ask them, were you prepared for your deposition? Do you recall who prepared you? How long do you estimate it would take? So there's going to be further evidentiary presentation, but what's in the record already absolutely raises a reasonable inference that Old Ironsides paid reasonable attorney's fees to its Cleary attorneys. I think that defendants' main move and main argument on appeal is this notion that it is so speculative that the jury couldn't award any amount of damages. And that's just not borne out by the record. We have the chief financial officer, the chief compliance officer, multiple Old Ironsides partners testifying to things that we know that Cleary did and that we know took at least some amount of time. And so the idea that the jury couldn't return even a modest award on this record that would be non-speculative, I don't think it's consistent with the record. And that is the only relevant inquiry for summary judgment. And I don't want to interrupt if Your Honor wants to jump in, but I think that is the key thing. And part of the narrative that defendants tell is this question of the unredacted time entries. And I just want to be really clear, I don't think the time entries are relevant to the issues on appeal. Defendants concede that there's not a bright line rule mandating that you always have to have unredacted time entries. So the only way they would come into play as a relevant consideration at summary judgment would be if there was no other evidence of damages in the record, such that that was our only evidence. And that's just not the case here, because we do have this separate deposition testimony, the interrogatory responses, which are specifically allowed to be considered, and were based on the knowledge of Old Ironsides as an institution as to what work it did directly with Cleary. And again, I do want to underscore on that the common sense idea that this was a massive investigation. Outside counsel doesn't work in isolation without communicating with their clients. There's testimony in the record that Cleary was giving weekly updates. In fact, the day of the week is named, it's Wednesday. Delmore says we had Wednesday calls with Cleary. And so that's another very concrete example of what was Cleary doing with its time. At minimum, it was satisfying its ethical obligation to keep its own client apprised of developments in the litigation. Now you can ask, okay, well, do we know exactly how much time that took? We don't think you need to know the exact amount of time. We know it was more than 0, and for purposes of summary judgment, that's sufficient, and further testimony can be elicited at trial as to how long those calls were.
Why wasn't it in Judge Salinger's discretion to rule that absent expert testimony under that footnote in Klein v. Shearwater, your clients could not prove damages?
Yeah, Your Honor, so I don't think it is right to read Klein as suggesting that there is discretion to mandate the use of an expert when there is already other sufficient evidence in the record to satisfy the summary judgment standard. And so I think that would conflict with the summary judgment standard. So it can't be the case that a trial court can require an expert when there's already other sufficient evidence. I think that the Superior Court here essentially was focused very much on the $20 million figure, the full amount of the damages. And in that context, it said you would need an expert to justify the $20 million. No, we don't agree with that, but I think even even setting that piece aside, at minimum, I don't think the jury needs an expert to know that Cleary could reasonably dedicate some hours to this representation, and that Old Ironsides would, reasonably have to pay them for that work. And that's what the jury would need to find. And where the evidence is in the understanding of a jury, then it's not proper to hold that a plaintiff loses outright simply because they don't have an expert. And defendants rely on the Global Investors case, and I think that's actually a helpful case for us because it's in a case where there wasn't an expert presented. The plaintiff went to trial, asked for, I think, 90-some thousand in damages, and the plaintiff didn't get all of that in the award. The jury decided to award less, but that underscores just because we may not ultimately recover the $20 million at the end of the trial doesn't mean that we don't have enough evidence here in the record to survive summary judgment. And I do want to make one more point on Klein. In Klein, the plaintiff conceded that parsing between the two claims that were at issue there, so it wasn't about reasonableness, it was about two separate claims. Parsing between that was effectively impossible, was the language that the plaintiff itself was using. So it was saying it's impossible to parse. And in that circumstance, of course, the trial judge can say, well, you needed an expert in order to do the legally mandated parsing. That's not at all what we have here. The jury did not need an expert to hold that Cleary reasonably, for example, was present at the depositions and that Old Ironsides needed to pay them for that. And basically all we want is an opportunity to be able to present that evidence to the jury and for the jury to determine the appropriate award. And that's what we've been arguing all along throughout this case. Just very briefly on the exclusion of our expert, the court doesn't have to reverse on the exclusion of the expert in order to reverse the summary judgment order for the reasons I just described, but we do think it was error for the Superior Court to exclude our expert who considered much of the same evidence that I was just discussing here and then brought his decades of experience to bear on that evidence in order to, to opine on the reasonableness. So we think the defendant's arguments on the expert really go to weight and not admissibility, but either way, at minimum, the summary judgment ruling should be reversed. And I see that my time is up.
All right, thank you, Counselor.
Thank you very much.
Whenever you're ready.
Thank you, Your Honors, and may it please the Court. My name is John Soretta for the defendants. We would ask the Court to hold that the trial court properly struck the expert testimony, and then having properly struck the expert testimony, properly granted judgment as a matter of law and summary judgment because there was no competent evidence of compensable injury on the claims at issue here. I'd like to start, subject to Your Honor's questions, of course, where my colleague left off, and that is on the exclusion of the expert, because I think it really informs a lot of what my colleague has been talking about up here. So Mr. Brew had an expert report that didn't have access to all of the detailed information, the time entries, any sort of factual basis on which to enter admissible opinions about the damages here. And that's because of decisions that were made in discovery and discovery orders that are the law of this case and not challenged on appeal. And I think it's useful it wasn't emphasized in my colleague's argument, just to go through why there was no abuse of discretion here in striking Mr. Brew's testimony. So Mr. Brew's report, which is in volume 1 of the record, from 709 to 753. Most of that is the appendix of the document he looked at. But it's really pages 7 to 10 of that report, I think 715 to 717, that talks about his opinions with respect to Cleary's fees. And the language that is used there is why Mr. Brew's report was struck. So it's, my expectation would be that thus and such would happen. Undoubtedly, Cleary did X, Y, and Z. Surely Cleary would have done this. It was basically, Cleary's a good law firm, and I know a lot about these SEC investigations, and so surely Cleary must have done all these things that I don't have any documentary basis for. And there was no abuse of discretion in that. And I think that goes directly to then, okay, if you're with us that far, why should you be with us on the grant of summary judgment? If we're right about the expert testimony being properly struck, then why are we right about summary judgment? Well, the reliance materials in the appendix, that are listed in the appendix, 285 documents. Those are the things that the jury's going to be asked about if there's a trial here. They're going to have to sort through that on their own to try to come up with a damages number at trial. And just as Mr. Brew was unable to do
They'll have
it with,
attorneys to argue in front of them and give them some direction. They won't have to do it all by themselves, right?
they will have attorney argument, but they won't have the benefit of expert testimony. I think it'll be just as speculative, more speculative than what Mr. Brew had to do.
Well, I mean, what your friend says is, you know, maybe we can't get anywhere near the 20 million, but we'll be able to present enough evidence that a jury could find that some of the attorney's fees were reasonable. I mean, at least the time they were spending next to the employees at the depots and preparing them for it. Why? I mean, that's going to be a much smaller number, but it does eliminate the 100,000 of cost. Why isn't that right?
Yeah, so our basic submission here is that it's the exercise in the jury room is going to be more speculative than the exercise on paper with the same documents, the same deposition transcripts, interrogatory responses, and 80% of the documents here are just cover pages that have a monthly billing amount. So we think it's going to be just as speculative and fails to create a genuine issue of material fact as Mr. Brew's report that was properly struck. So for example, at trial, if there were to be a trial here, it wouldn't be that the jury would, that counsel would say, well, there's some deposition transcripts, there's some interrogatory responses, surely at least $1 must be reasonable. Go back and write down a number. No, the jury's going to have to actually have a non-speculative inference of a particular dollar amount.
Why couldn't someone say, okay, you heard from 10 employees, they each had 10 hours of depositions, so that's 100 hours right there, the appropriate fees or whatever the fees were in there, so at least we get that.
Right, I mean, so even as to that, right, my colleague on the other side said there's 4 timekeepers of a core team. I think that's from 2016. But if you look at, we block quote this in our brief, Mr. Brew's deposition testimony, he doesn't know even who's the core team throughout the whole period. Who are the timekeepers? Who's reviewing the documents? How many documents are being reviewed? So, I mean, there's no non-speculative inference that can be reached, and that's why I think this is right in line with Klein. And a lot of good out-of-jurisdiction authorities that are right in step with Klein, where if you have a matter that's beyond the ordinary understanding of a jury, a complex SEC investigation, okay? We cite the Connecticut Appellate Court decision, patent and trademark work, you know, complex legal fees that are just beyond the ordinary understanding of the fact finder. You need expert testimony on that to get to a jury. You need it. So in St. Ange, that case I'm referring to, which I think is very persuasive in Connecticut, they don't say, well, it's patent and trademark work. You got to do something. So some amount of this $150-some thousand attorney fee should go to the fact finder. No, they say this is beyond the ordinary understanding of a lay jury and judgment as a matter of law. Same thing in Klein, which I recognize that a lot of the analysis here was in a footnote, but that doesn't make it any less binding precedent of this court. You have an abusive process claim. If you look at the briefing in Klein, which I was looking at this weekend, you had $1 million of fees. Okay, so something, I mean, yeah, could you have hypothetically said, well, I mean, $1 of those fees has to be reasonable, let it go to the jury. But no, that's not the holding. The holding is that it was within the trial court's discretion to say without expert testimony, you don't get to the jury because the jury is left at sea. Even more so than this very experienced SEC practitioner is at sea and is left in his report to say, Cleary would have done this. My expectation would be Cleary would have done that. A lay jury doesn't even have that experience to draw on in the jury room. And that's why we think summary judgment was appropriate here. A couple other points subject to Your Honor's questions. I do just want to briefly talk about, a little more about really, because I think I've been talking about this some injury argument, that all you have to do is show some injury and that gets you to the jury. I don't think that's the case here under Klein, this court's binding precedent in Klein, under the out of jurisdiction cases that we cite. But there's also, just very briefly, as we say in the brief, I mean, that wasn't the argument, the some injury argument is new here. Below it was, no, the overall amount has to be reasonable. And at 332 of Volume 1 of the record, this is what I'm citing to. It's not a sum injury argument that was made below, but rather the relevant question is, quote, is whether the, quote, overall cost of the defense is reasonable. So that's not how this was presented to the court below. Now, even leaving aside waiver, as I've been saying, I don't think the jury can really engage in any sort of non-speculative fact-finding on this. Klein, which I think is a key case on this point, in the reply brief, my colleagues on the other side said, you know, Klein is directed verdict. It's a different situation. It involves parsing between claims. Well, a couple points on that. First, the directed verdict standard under this court's cases, the Supreme Judicial Court's cases, is functionally the same as the summary judgment standard. There's a 2006 Supreme Judicial Court case, I'm quoting from it, Donaldson versus Farrakhan, 463 Mass 94. The, quote, the standard applied to a motion for a directed verdict is identical to that applied to a motion for summary judgment for most purposes. Well, for these purposes, whether you can get to the fact finder without expert testimony on a very complicated question of what legal services are reasonable, beyond the ordinary understanding of a jury, summary judgment and directed verdict should be the exact same result. Also, I just want to briefly mention, because it was in the reply brief for the first time, nominal damages. There's a reference to maybe nominal damages on these claims. Well, if the case were to go to a jury on a nominal damages theory, that was never, again, never argued below. First time I think I saw it was in the reply brief, but that would not be a basis to reverse here. And just one cite on that, because it was in the reply and we don't get a surreply. Schwartz versus Travelers Indemnity, 50 Mass App Court 672, talking about how no useful...
15672?
Yeah, 50 Mass App Court 672. In the case
15 or 50? You say 15 or 50?
I'm sorry, 50. My apologies. Yeah. And that's a case where they were talking about, okay, does this have to go back on a nominal damages theory? No. Quote, no useful purpose would be served by remanding the matter simply for an award of nominal damages. So if that argument about nominal damages were enough to go back, I don't think you would send it back on that theory alone. And that's really all, I mean, even if all these other hurdles were reached, I just don't see a non-speculative inference, and I think the trial court was exactly right. I mean, my colleague on the other side says, okay, well, we have cover pages of invoices on monthly bills. We have subpoenas, so we know there was subpoenas, and it seems like a big deal. We have an order, and then we have some deposition transcripts in which some witnesses say, I was working with Cleary, and Cleary was keeping me up to date on what Cleary was doing, and so from that, a lay fact finder is going to go back and write down $2 million. Or $5 million, or $20,000, or $20 million. There is no non-speculative way to do that, and that is why the proper rule, as the trial court here properly held, and as this court affirmed in the Klein case, is that in this area, you're beyond the ordinary understanding of a jury. And if your expert testimony is out, then you should be out of court. And we would ask the court to hold that here. Unless the court does have questions, I will leave it there. Thank you very much.
All right. Thank you, counselors, both of you. Welcome to Massachusetts. So that, and we'll take the case under advisement. It's been very, very helpful, both argument and briefing. So that concludes the court business for today. I'd like to thank our court officers who definitely earned their pay today. Not supposed to be chair movers, but that's what we got. I thank our timekeeper, our clerk's office, and all the attorneys who appeared in front of us today. As I said, we're going to go off the bench, we're going to take off our robes, and then we're going to come down and talk to all you interns, so I hope you'll all stick around, and we can have a conversation afterwards. And with all that said, court is adjourned until Monday, July 13th.